All right. There we go. Ah, it's been a couple of weeks of where there's just been problems in starting the stream. So here we are. Welcome this evening to a very special kind of edition of Reading the Receipts. I said last time, if things were, packed this week on the docket, that we would do an extra episode. And then, of course, we got all of the decisions for the motions to dismiss. So that is what we're going to talk about tonight. Thanks everybody for joining me on this unusual kind of weeknight edition of Reading the Receipts. So thanks, guys. Hi, Obi-Wan Kenobi, Marcy Jinx, Gina Richardson, Sylvain, Muckamuck. Glad to see you. Thanks for everybody for joining in. So yes, today we're going to just basically go through the motion to dismiss. We're going to read Liman's opinion, and we're going to talk about why it is that this case was dismissed entirely. And I think I want to start out by just talking really a bit around the case, and then we'll get into it. Before we start, as always, our disclaimer, right? We're about to read a legal document, but I am not a lawyer. I'm certainly not your lawyer, and none of this is legal advice. All of the allegations we're going to cover are just that, allegations. Nothing has been proven in court, and nothing that we talk about should be taken as a point of fact. This is all just my opinion, my misguided, uneducated opinion provided for entertainment purposes only. Muckamuck, you're able to hit one of these live. Awesome. Well, we're glad to have you. So yeah, like I said, I want to start out tonight with talking about a Reddit post. Thomas Smith of Gavel Gavel, as a result of the motion to dismiss, and with Baldoni's entire case being thrown out, took time to post to one of the subreddits. Now, this is a subreddit that styles itself as a kind of a neutral subreddit. I can tell you right now, anybody who doesn't completely defend Baldoni will find themselves utterly downvoted. And you can see here, Thomas's post here has been sat on zero karma since he posted it, because it has been downvoted into oblivion. But I really liked this post because I would like this to be the spirit of which we kind of take the rest of the evening and can talk about this. And in here, he basically kind of makes this plea to say, hey folks, it's me again. I'm not here to gloat. He's been here commenting, and every time he comments there, he gets pushback and resistance, but he still keeps trying. And many of you often ask, why am I even here and what my goal is? And I've answered, but today, as Baldoni's case has been completely dismissed, it bears repeating. The biggest reason I'm here and I'm covering this case on my show is that you are being lied to by people who know better. It's been clear from day one that Baldoni's case was nonsense. You can find many times I've said this exact thing, and this is what I meant. It was a fake case drummed up as a defensive PR effort. Right now, I already see the scrambling to explain what happened in pro-Baldoni terms. The temptation will obviously be strong, but the truth is there is just no spinning this result. Baldoni had no valid claims against the lively parties. The only two that he's even allowed to refile are because technically the judge could not rule them out as a matter of law, but they're not meritorious, and it isn't close. And so he basically encourages just this reflection of how do we get here, right? For a lot of people, this decision, was a surprise to them. They're very dismayed, and they're like, I don't get it, and trying to piece it together, and encouraging that reflection of how did you get here, right? Because you consumed content from people who told you that this was a slam dunk, that, he was going to completely destroy her and all of this stuff. And there are still people drumming the beat of that drum in the wake of this. And I need you to understand, if you are one of those people and you are kind of hate watching my content to kind of see what I'm going to say, I encourage you to take the moment for that reflection. It is so rare for an entire suit to just get thrown out completely. There were so many claims in this. There's so many people involved in this that nothing survived is a big deal. And it shows just how weak his case was and how he didn't have any valid legal grounds to file suit. And that's what we're going to talk about as we explore this. It's not just that he didn't make good arguments. It's that even if you took them in the best possible light with all of his evidence, it does not rise to the level of something the court can action on. And that's a real reason why he lost his entire suit. So it's pretty damaging. And like I said, we're going to get talking to it. Junk Farm, good to see you. Or Scientist, oh my goodness, good to see you. I totally made a gloat video, and that's fine. Look, it's been an exhausting, 6 months, 6.5 months of this constant media frenzy and of us being constantly told we're paid. And, I had people even in the days before the dismissal telling me, they'll be coming back to my account, they'll laugh when he's going to win and all of this stuff. So like, I understand that temptation, but I do think like if you're somebody who disagrees with me and you are watching this content, I encourage you to take that moment of reflection of not necessarily about, your team won or your team lost. Why is it that the content you consumed was so wrong about this? Was so wrong about the outcome? How were they not able to see what was coming? Vander V, Belmoon, good to see you both. Thomas trolling the neutral sub has been the highlight of my weekend. I enjoyed it. I mean, like, he's in there trying to fight, and good on him for kind of taking the moral high ground and kind of putting this post in here. It did not have the intended effect, clearly. zero votes. But I appreciate the effort that went into it, the attempt to reason and understand, to humanize the people that we disagree with and encourage reflection. I think these are all good things and help to get out of the contentious partisan atmosphere that we're in and that we're still in, right? Like, there are so many creators that I've seen who, even with this motion to dismiss, being complete and utter annihilation of his case, not a little bit, entire thing, still saying, well, I don't care what the judge says, I know the truth. And it's crazy to me because it talks, I've talked about this on my TikTok. This weaponized, not incompetence, but this weaponized ignorance, or where the bar that you need to change your mind is so high, right? For you to change your mind on whether Blake Lively was telling the truth, well, I would need all of these documents and blah, 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 and all the rest of stuff. But the bar for you to believe Justin, even as his case gets dismissed for not being convincing, for not having any grounds, not having any evidence, you're still fully believing him because the bar is so much lower. The reality is there is no level of evidence that would get you to change your mind. And it's frustrating. Frustrating to deal with people who are like that on those other topics and think, the best thing is to just save your time and energy and not engage. Says the man who spends, a good deal of his time on social media engaging. I realize. The judge saw right through his BS. Yep, most of the people who disagree with you aren't doing it in good faith, unfortunately. Yes, and better off go spend your time and energy and effort doing something better. All right, so already, we've seen the reaction from Baldoni's lawyer, talking about how it feels after it's been dismissed. They have said, Friedman has talked about how they've been invited to amend 4 out of the 7 claims. This is not correct. I'll talk about that in a second. Against Lively, and that they're going to continue. Friedman also claimed that Lively's allegations are no truer than they were yesterday. This is not the case, and we're going to talk about that as we go through what Judge Liman was talking about. And with facts on our side, we will march forward with the same confidence we had when Miss Lively and her cohorts initiated this battle. Talking about like he's looking forward to her deposition that he'll be taking shortly. It's I highlighted here talking about with facts on our side because again that's going to be another point of issue that we're going to talk about today. An insider, an unnamed insider on Baldoni's team, even though it's a stumble, Justin still has full trust with his legal team. He's looking how to figure out how to move forward with his current setback, and feels like this is a huge kick in the guts. And yeah, would be. Your entire case just got thrown out. Nothing survived. It's terrible. The judge wrote that Baldoni and his production company have not alleged that Lively is responsible for any statements other than the statements in her CRD complaint, which are privileged. Again, we'll get into and talk about that. But also the Wayfarer parties have not alleged that Reynolds, Sloan, or the Times would have seriously doubted these statements were true based on the information available to them, as is required for them to be liable for defamation under the applicable law. That I highlighted because I do think as we go through this, this is going to be a big piece of what we talk about in this motion to dismiss. Based on the information available to the people at the time, there's no reason for them to doubt the story they're telling. And this is huge. When Baldoni's talking, or Friedman, I should say, specifically is talking here about we have facts on our side, her claims aren't true. Part of that is in this motion to dismiss, Liman's putting himself into the shoes of the people who've been told these stories and don't have any reason to doubt them, and concluding that yes, there is justification for believing these things are true based on the evidence, even as Baldoni himself has presented it. That is problematic as we march forward and go to Lively's side of the case, where we're trying to argue the sexual harassment, and that more importantly, as an employer, they ignored and dismissed those claims of sexual harassment, because he's saying, look, the people who were around Lively and hearing these stories and seeing these text messages wouldn't have a reasonable doubt to believe that this was false. So if he's going to say that evidence is on his side, he's already off to a shaky start. That we're already saying, look, if you present this evidence to a normal person, their conclusion would be that Lively is telling the truth. All right. Already lying. Yeah, I mean, he got that wrong, and I'll talk about that. But to be fair, I made the same mistake as Friedman, so don't be too harsh on him. He's, he made the same mistake I did. He also made more statements, again, in an interview on TMZ, talking about Justin's reaction was the same as mine. It's not fair and it's not right. As we get into the motion to dismiss, Liman is incredibly fair to Wayfarer. And the other point of this motion to dismiss is, because it's a motion to dismiss, he starts out and has to from the point that everything Justin Baldoni is saying is true. This is not an opinion given based on, I've seen, Lively's facts, I've seen Baldoni's facts, and I'm weighing between the two of them. He's saying, forget everything that Lively says. If I just take everything that Justin says as true, he still has no case. That is how weak his underlying case and claims are. And I think that really just needs to be emphasized, right? This motion to dismiss is based on the fact that I have to, as point of law of like deciding this motion to dismiss, I have to accept everything Justin is telling me is the true and correct version of events. And even so, the judge came back and said, even if all of what you're telling me is true, there is no claim here. And that's bad. He's a person who wants to be vindicated. He knows who he is. He knows what he's done, which, okay. He knows what he hasn't done, and he wants the truth to come out, and he'll do that in the appropriate way. He's waiting for his day in court where he can speak out to tell the truth, which is a wild statement to give, given that you've spent the last 6 months arguing in the press that you were going to destroy her, and your case is so cool, and you've got all this evidence, and blah, blah, blah. And you couldn't even bring a single actionable claim, not one. We'll also talk over the two that are not dismissed with prejudice, because as Thomas pointed out, those are not guaranteed from the language that Liman had put in there. So he's saying it's far from over. So they're going to continue to retaliate and go after her. And they've also talked about they're going to amend their case. We're going to show there's no smear campaign. They're just continuing and doubling down. This is not going to go well. Of course, Lively's team came out and talked about, hey, this is a message about these kind of retaliatory lawsuits. We spoke about that a little bit in the amicus briefs. We'll probably speak about that again on either Friday, Saturday, when I do this week's, I think it's Saturday is going to be this week's stream, where we talk about like abuse dynamics and Davo. But I mean, like this is huge for them in terms of not just Lively, but also for everybody else who speaks up and speaks out about sexual harassment and sexual misconduct, because of what this means in terms of dismissing these lawsuits. So, the case summary from Baldoni's point of view was more coherent than Baldoni's actual complaint. There are some call-outs in there where the judge has to like piece together pieces of it. All right, so let us then just get into this thing. It's 130 pages. I typically have about 4 to 5 pages of show notes. I have 10 pages of show notes today. We're going to be reading a chunk, lots of it from it. I usually only kind of do excerpts. We're going to be reading quite big chunks of it tonight. I don't know how long this is going to take. So make sure you get your rest breaks in. Go to the bathroom. Make sure you get your drinks. Hopefully I get you out in here in less than 3 hours, but we will see. If you have anything you want to call out as we go in chat, please do, and we will dig in. So, as talked about, this is a total, a combined opinion based on all of the motions to dismiss. I think, a couple of the lawyers I talked about were talking about they probably wanted to do kind of hearings beforehand, gather everybody together to kind of sort out and piece things together, and it doesn't look like that happened. I know Kat Ortega had talked about, this kind of thing is like, when it's this complex and there's all of these things, there's typically like these hearings to get everybody together, to get everybody on the same page, and Liman didn't really need that and just kind of sought it through. Again, I think that's just because it was quite damning. The other thing to note as we go through this, legal arguments, again, I talk about this like I know what I'm talking about. Understand, as we said at the beginning, not a lawyer, and to the lawyers watching this, I apologize. But in making legal arguments, they're like ogres, right? They have layers, right? So a lot of times they'll make an argument, and if that doesn't work, they'll make a secondary argument and a tertiary argument, and so on and so down, right? And so what you're doing is you're saying, well, this is the case, and if that isn't the case, it's this and this and this. You're creating these layers of shield around your argument to say, I've got all of these defenses, and even if you get through the first two, you won't get through the third, the third and the fourth. In Liman's opinion, he often doesn't even get through the first layer of defense. He kind of throws it out based off the first argument. That's telling. When we talk about like the California stuff, he doesn't get into the California stuff, the Civil Code 47.1, this whole retaliation lawsuit that the amicus briefs were filed about, and that Lively had invoked in order to get triple damages. None of that is invoked or discussed or even talked about because that is layers deeper, and he dismisses based off like, you didn't even file like an actionable claim. You didn't even plead this correctly. So that is up for discussion later and will probably come. Heidi the sausage, good to see you. F the patriarchy, good to see you. All right, so yes. All right, so we're gonna dig in. I'm gonna find my notes. All right, number 5. I will not be going through much of like the background of as he tells the story. I will say, we know the story at this point, but the important point to point out is, as I talked about, for the purposes of this motion, the court accepts as true the well-pleaded allegations of the Wayfarer party's amended complaint. Accordingly, the narrative set out below does not reflect the court's own findings. I've seen a couple of people on social media talking about, well, the judge agreed that she was lying, or that Lively wasn't telling the truth, or the judge agreed that Baldoni, like, no. The judge and the court are not agreeing with Baldoni in this. They're just saying, here's the story that Baldoni presents. Based off that, I'm going to give him the best reading of his complaint. It simply repeats the accounts of events stated by the Wayfarer parties in their amended complaint. At this stage of the proceedings, the court has not considered whether the allegations in the amended complaint are true. Important point. He's not making a decision about whether what Baldoni is saying is true. He's just saying, if what you're saying is true, does it then logically follow that you incurred these damages, these acts happened, and that you have the ability to go to the court to get the relief from those damages that you are alleging, right? Those torts that you're alleging. Can be throwing out legal words, probably misusing it, but you know what I mean. So that's the context of this, right? We're not talking about, oh, Baldoni I don't think is convincing, he's not being truthful. That's not part of this. All right. In addition to the allegations in the amended complaint, the court has considered several documents which are deemed to be part of the amended complaint as a matter of law. So he talks about if a complaint makes a reference to a document, for example, by quoting from it, the entire document is deemed to be part of the complaint. In a contract, for instance, like if the complaint relies heavily on terms and effects of a document, like a contract, but for some reason does not include the entire document, the court may consider the entire document as part of the complaint. The purpose of this rule is to prevent a complaint from surviving simply because a clever plaintiff included certain parts of key documents and left out others. Under this standard, the amended complaint is deemed to include the New York Times article that is subject of the defamation claims, the accompanying video, Lively CRD complaint, the list of 17 protections for return to production, emails between the New York Times and the Wayfarer parties, and each of those documents is extensively quoted and discussed in the amended complaint. Let me see. Yeah. Oh, I didn't download the motion to dismiss. Oh well. So in determining whether the Wayfarer parties have stated a claim for relief, we're not considering the timeline of recent events, right? Under the federal rules of civil procedure, it's supposed to be done with paragraphs so that the defense can, form a response to it. This was the argument when they asked to strike it in their motions to dismiss, that it was improper pleading. He agrees it's improper pleading, but he's not striking it from the docket. He's keeping it. Okay. He then talks about, where's number 5? Okay, the inclusion of documents. So the reason he was calling out, if you talk about something and don't include it, we're going to consider, the court's going to consider the whole thing, is because part of their motions to dismiss, in responding to the New York Times, it talks about, hey, the Wayfarer parties don't object to the consideration of the New York Times article, their video, the CRD complaint, or return to production demands, but they do object to the consideration of the emails between the Times and the Wayfarer parties. As part of their opposition to the motion to dismiss, New York Times argued, hey, look at these emails, they don't include a contract, so how can it be promissory fraud? We never promised them anything, it wasn't a contract. And in response, they were like, oh, you're referring to emails that are not part of the complaint, and you haven't included them, and you can't just bring them into your motion to dismiss. Liman's specifically calling out that the objection is unavailing because the Wayfarer parties in themselves pled in their complaint that the express written words of the emails created an implied in fact contract, which the Wayfarer parties accepted and the Times breached, pointing out basically that he's complaining, Baldoni's complaining in his complaint about the emails, and referring to what's in them, but then refusing to allow the emails and what's in them to be discussed or up for discussion, when that is the key point that they're arguing over. So I thought that was interesting. I had missed that they had called out that they can't have that, because they actually quote the entire email they give back in response in theirs, in their complaint. So it's wild that they're like, oh, you're not allowed to say the email that we're complaining about had a contract in it. Wow. Talks about the parties. I don't think we really need to go through them at this point. This is where he talks about the timeline of recent events. He says he's not going to strike it. He argues that Exhibit A is largely redundant of the amended complaint, and given it must be disregarded, is immaterial to the court's decision on the motion to dismiss. So he's saying, I'm not considering it, I'm not including it into my facts, it will get referred to. But the fact that the material is irrelevant or must be disregarded does not justify striking it from the docket. He's saying, look, I don't need to go to, that level, arguing there that the document itself is no more scandalous than the amended complaint. After all, it repeats a lot of the amended complaint. He calls out here, if the Wayfarer parties wanted any of the statements in their timeline to be considered, they should have alleged them in the amended complaint. So already he's getting off to a little bit of snark with this discussion. So like I say, I'm not going to read through all of this, because I think at this point, everybody here is familiar with the story. He is, like I said, taking Baldoni's version of the story. So a lot of this is, talking about not just the strike, but also about the comment about fat shaming, stating that, he was worried about his back, that the gratuitous scenes were added by the intimacy coordinator, not him, all of this stuff, right? So he's taking Baldoni's complaint as true and his version of the story, where, Lively takes over the movie, demands things from them. They feel like they had to acquiesce, was being uncomfortable with certain things, but, talking about him saying it's sexy to her, recognizing that she appeared offended, apologizing multiple times. Like, he's really just taking Baldoni's best possible lie for this, right? All right, so we'll go through all of this. Unfortunately, this scopes like a huge chunk. You can refer to the entirety of the document if they only clip a tiny little bit. Not a liar, and I know that. Yeah, don't bring it in. Don't bring it in. If you quote it, they can bring in the rest of it and say, actually, what it really means. And again, you can do that because exactly what they were trying to do. Quote a piece of the email out of context and claim that it had other stuff in it while it didn't. Where are we? Goes through the procedural history of how things were filed and what filed. We're done. Okay. Legal standard. To survive a motion to dismiss, the complaint must include sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. So again, reiterating what we're after here, that if you accept his allegations as true, there is enough factual material for them to actually be able to have a claim for damages at the end of it, right? That's what we're looking for. I can't tell. That light looks too hot. I thought it was like not hot enough. A little better. A little better. Still very red. The ultimate question is whether a claim has facial plausibility. The plaintiff pleads factual content and allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged, right? So that's what we're looking for. If we take your everything you say as true, is there enough factual evidence to support a claim, right, for damages? Did that. So the amended complaint focused broadly on two types of claims. First, the Wayfarer parties claim that Lively, assisted by Reynolds and Sloan, stole the film from Baldoni and Wayfarer, threatening to refuse to promote the film and attack Baldoni and Wayfarer in the press if the Wayfarer parties did not agree to grant her, rather than Wayfarer, control and credit for the film. Interestingly, although that's what he alleges, she never got credit for the film. Like, it was still always a Baldoni film. And we didn't even know anything about her part of it until all of this came out. He was quite happy to be, filmed by Justin Baldoni, directed by Justin Baldoni, and take all of the credit. Second, the Wayfarer parties claim that Lively, Sloan, Reynolds, and the Times spread a false narrative that Baldoni committed sexual misconduct towards Lively, and the Wayfarer parties then engaged in a smear campaign to ruin her reputation. The Wayfarer parties claim that by doing so, Lively, Reynolds, Sloan, and the Times committed the torts of defamation and false light. Although these two types of claims are the focus of the amended complaint, the Wayfarer parties also bring claims for breach of contract, tortious interference with contract, or prospective economic advantage, and promissory fraud. The Wayfarer parties cannot recover for Lively's alleged actions to steal creative control of the film from Baldoni and the Wayfarer parties. Regardless of the propriety of these actions, they do not constitute civil extortion under California law. So we start out by him saying, look, it doesn't matter if what you're saying is true about Lively being difficult to work with, demanding things, and taking control over the movie. The way that she went about it, as you describe, is not extortion. You have no claim for extortion. So we're already in the intro to this, and he says, your claim for extortion, dead. This was their first claim. California courts have recognized a claim for civil extortion in situations where a plaintiff gives a defendant money or property under the threat and seeks to have it returned. However, the Wayfarer parties have not adequately alleged that Lively's threats were wrongful extortion rather than legally permissible hard bargaining or renegotiation of working conditions. Additionally, the Wayfarer parties have not shown that some of Lively's allegedly extortionate acts damaged them. So the other piece of this is, even if she made these kinds of threats, you didn't show that they caused you harm and damage, which is an important piece. It's not just that they're doing this conduct. You have to show that you were somehow damaged or made wrong by this so that the court can make it right. And if you can't, well, then you don't have a claim. All right. The Wayfarer parties cannot recover on their defamation claims. Wayfarer parties have not alleged that Lively is responsible for any statements other than the statements in her CRD complaint, which are privileged. And this is also huge, right? Their entire basis of their defamation claim was that by publishing this in the New York Times, it damaged him and defamed him. They're pointing out that, look, he's pointing out that, look, you haven't alleged anything other than that, and that is protected. She didn't say anything else. She didn't make any other statements to the press. There was nothing else going on. The Sloan and Reynolds comments are separate, but you have nothing that you can recover from her. The Wayfarer parties have alleged that Reynolds and Sloan made additional statements accusing Baldoni of sexual misconduct, and that the Times made additional statements accusing Wayfarer parties of engaging in a smear campaign. But the Wayfarer parties have not alleged that Reynolds, Sloan, or the Times would have seriously doubted these statements were true based on the information available, as is required for them to be liable for defamation under applicable law. This is, and you've heard it a bunch of times, the actual malice standard. And we'll get into it as we get further in and dig into this because Lyman actually calls it out. But a lot of people have kind of, especially like on social media, misunderstood actual malice to mean like they had actual malice, right? Like they were being mean and they wanted to cause harm and damage. That is not the legal definition of that term. The legal term, as Lyman will get in later, is that you said things that you knew to be false, right? You intentionally kind of defamed something. You intentionally caused damage to somebody. You repeated something. You knew something was false in saying it. He's saying that based on the evidence that they had, there's no reason to doubt that they were not saying what they thought was a truthful statement. So it's not defamation. The Wayfarer party's additional claims also fail. Accordingly, the amended complaint must be dismissed in its entirety. However, the Wayfarer parties have leave to amend their claims for breach of implied covenant and tortious interference with contract. And I forgot to talk about this, but this will be the point where I remember, because we can segue back to this. Coming back to the complaint, I was so happy that I made this slide last week because it's come in really useful. This is Wayfarer's complaint as it stood. They alleged 9 causes of action. For the most part, all of their causes of action are with all plaintiffs. So Baldoni, Heath, Wayfarer, Sarowitz, Melissa Nathan, Jennifer Abel, and it ends with us movie LLC, alleging these damages against, and you can see here on the right hand side, the various defendants for every claim. They're not all the same. They're different, right? That was their lawsuit as it stood. The aftermath of this was from his comment here that Lyman says, oh, I just got back out of that. There we go. 37, I think. It's 37 or 38. One moment. Come back. Okay. For a breach of implied covenant and tortious interference, my understanding was that would leave 4, right? And it would leave the 4th cause, breach of implied covenant, and then the 5th, 6th, and 7th causes, because they are all this intentional interference with like the different contracts. That I think is where Friedman was saying, hey, we're allowed to replead 4 of our claims. As we'll get into later, that's not actually true, because later in the opinion, Lyman will actually call out that the 6th and 7th cause are also dead as well. So literally the only thing that is open for them to replead and try again on is the breach of implied covenant and the intentional interference with contractual relations, because we don't have the contracts. Because Wayfarer have not provided those contracts, Lyman's open to, well, I don't want to dismiss this yet until I have those contracts. If I can see those contracts, I can then tell you whether these claims are dead, or whether there's a chance maybe they can survive. But that's how bad this is, right? Like their entire case is dead as it stands right now. The only pieces that they can revive are these 2. If Friedman is truthful about his threat to amend and carry on, they will probably try to bring in a bunch of new causes and other stuff. But I don't think that's going to be terribly impressive in the same way of what they did with Abel, where when you drop a bunch of your causes and so you just invent a bunch of others. And I think that will, if we don't already get rulings on like the sanctions and kind of fees for frivolous lawsuit, them just refiling with new claims and changing everything is going to make that happen. So as much as he's in the press arguing, we're going to refile, we're going to add all of these claims, I don't necessarily think that's a smart legal strategy, but I mean, that hasn't stopped Wayfarer so far. So, right. How it started versus how it's going. Yeah, exactly. How it started, how it's going. It started, going. They're all TikTok attorneys. Yeah, and it's like not even like the TikTok attorneys. The actual lawyers on this are also putting out some really, really bad takes. I will not name them. I'm not going to start stuff with them. These people have gone to law school. They are more educated about law than me, and yet they are still saying some really, really terrible, bad takes on this. I mean, they got this all wrong. I don't know why you would think that they're going to get it right more now. But that's just me. Master Jinx says 2 claims survive because they didn't provide enough info for the judge to toss them. Amazing legal work. Yeah, yeah. You did not give me enough evidence for me to definitely know you're full of shit. Like, that was the ruling. Like, it's bad. That's bad. That's not a win. So the choice of law. This is a big piece. I'm not going to go too much into this. If you remember from the whole motions to dismiss, a large part of this was arguments over what kind of law applies. So to recap, this whole case is now in federal court in New York, but just because the court is in New York, it doesn't necessarily mean that New York law applies. And part of this is figuring out what law applies to each of the claims and also each of the defendants in the claims. It can vary. So he goes through and talks a little bit about this, but a large part of the claims fail on their basis, so we never even get to choice of law. So in just kind of like pleading a claim for defamation, they fail to adequately plead it, so we never get to, well, does New York law apply or does California, like, because we don't even get there. Again, I need you to understand, right? Like, I'm not trying to pick, I'm not trying to be like, yay, lively. Like, that's how bad Baldoni's complaint was. Like, he didn't get dismissed on these technicalities and arguments over different pieces of law. He never even got through that first layer of the shield. All right, so that said, where did I missed this piece. Yeah, where they talked about for defendant on money, they hadn't, oh yeah, we did talk about that, about whether it was hard bargaining or renegotiation of working conditions. I did. See, we're already skipping this bit. All right, coming through all of this, he does kind of talk about, well, the dispute is important because New York and California differ in ways relevant to the parties' claims, and then starts to like break down pieces of them. I don't know necessarily there's a lot in here that's really interesting. It talks here about, as to the claims against Sloan and Reynolds, the court is unable to determine what law applies at this stage. When we get to the end to talk about damages, this is part of the reason why damages haven't been decided yet, is that Judge Liman's making these decisions without actually deciding what law applies to those claims. He's basically asking them, provide more evidence, provide more facts, help convince me which side of which laws apply. So he's not ruling on the damages because part of it is he doesn't know whether it's, the California laws that are going to kick in and cause those triple damages, or whether it might be New York law and it might be just, I think, New York's anti-SLAPP protections. It doesn't mean that damages aren't coming. It means that right now he doesn't know which law to apply in order to decide those things, because they do need to know like which law is going to apply to them. Fortuna says, I'm late. Well, we're glad you're here, Fortuna. We're just getting started, so don't worry about it. Get comfortable. He talks here about like the different pieces. Choice of law is not meaningful to the fourth and nine actions. The fourth cause should be decided under California law, which is against Lively. Just talking about these different pits. The parties have identified no difference between New York law and California law relevant to whether the Wayfarer parties have stated a claim for breach of implied contract. So I forget which clause that is. Whoops, fourth, fifth. So he starts picking the pieces apart from it to talk about it. Because it's unclear from the pleadings whether facts underlying the claims against Sloan and Reynolds occurred, the court cannot dismiss the claims based on the holding that they must be brought under New York law. If the allegations state a claim under California law, the claim must be allowed to continue until such time as the facts developed show California law does not apply. Therefore, the court will analyze the claims and against Sloan and Reynolds under California law for the purposes of the motion. So he's saying, there's this unknown decision about which law is going to apply. The more generous law would be to apply California law to Wayfarer's claims, so that's what he's going to do. So when I say like it's not fair, and he gave like a really fair reading of this, things like that are in here where he's saying, look, they haven't said which law applies. I'm going to give them the benefit of doubt and give them the best possible decision here, because it doesn't matter. That's how bad this is. However, the defamation and false light claims must be analyzed under New York law against the times. The Wayfarer party argued they should be brought under California law because they're California citizens and feel the impact in California. But they go on to say, the court distinguished between defamation cases involving a targeted publication, in which the plaintiff's domicile will usually have a significant relation to the case, and multi-state defamation cases, in which an allegedly defamatory statement is published nationally and the plaintiff suffers harm in every state. So he starts to talk about pieces of that. He talked about, because the false light claim is duplicative of the defamation claim, which we'll get into later, choice of law analysis is the same, so same law applies because the claim is almost the same. He talks about another case of defamation with the New York Times, arguing that New York had the most significant interest because the Times is domiciled in New York. The defamatory statement emanated from New York, and saying the same factors require application of the New York law to the defamation and false light claims against the Times here. The Wayfarers presumably suffered the greatest injury in California where they're domiciled, but that previous law says that this is not decisive. The events underlying the allegedly defamatory statement took place in New York, where Lively, Sloan, and Reynolds were based and sometimes met with Baldoni and the Wayfarer parties. California, where the Wayfarer parties were based in the filming location, which is not clearly specified, but at least some of which occurred in New York. Talks about, again, that's where the things emanated from. And then talks about here, they're arguing that it should be held under California law because that's where they're where they reside. I shouldn't say domiciled because that's not a word we would use. That's where they live in California, so that's where the choice of law should be. And Liman points out, well, Sarowitz lives in Illinois, but no point did you argue that the law of Illinois should apply to claims against him. So clearly that's not the basis here. You're being inconsistent in your arguing. And again, it's these little pieces that show the weakness of the argumentation. I will say this. I hope I never ever have to go up against a federal judge, because the attention to detail through this and the nitpicking through it is incredible, and I have a huge amount of respect for people who actually file complaints against federal judges now, because seeing him go through this and piecing these things together, I don't want to be up against this ever. No thank you. This is work. This is real work. I don't care. I don't want to do this. I love the word domicile, says Muck and Muck. So yeah, I don't think there's anything else in this piece. I have something for 40. Did I have something for 44? But no. Oh, the impermissible pleading. Okay, so we talked about this on last week. I think it was Friday, about the group pleading, right? Liman actually doesn't find this a compelling argument. It's one of the kind of few wins in this, I guess, is that everybody kind of complained about the group pleading, where it's unclear which defendant did which piece, right? He also talks about this footnote for the choice of law thing, talking about that Wayfarer parties argue that this case is distinguishable about Kinsey because it involves not only California residents but also Hollywood's entertainment industry, and because the article focuses on the CRD complaint. I don't remember what else I was going to say. I was going to say something on this, and reading this now, I cannot think what I was going to say. Footnote on 44. I don't know. I don't see the point that I was going to make on this. I'm sure it'll come to me after the stream is over. All right, so back to the impermissible pleading. The defendants argue that they lack proper notice of the claims because the complaint consistently makes allegations referring to the Lively parties and the Wayfarer party, leaving defendants unable to discern which of them purportedly injured which plaintiff and how. The issue is compounded by the fact that the complaint's length and tangents make it difficult to understand exactly how the facts alleged provide a basis for the plaintiff's claims. So, I mean, even he's admitting, it's not always easy to see what's going on in this complaint. But he does kind of make the point of, look, the Wayfarer's amended complaint is lengthy and repetitive, and it relies heavily on group pleading, but it is not so confusing or lacking in substance that dismissal is appropriate. He says, yeah, it's a mess. It's just not that much of a mess. he does say that, defendants have adequate notice of many of the core claims evident from the face of the complaint and been fully briefed by the parties. For example, it is evident from the language of the complaint that the civil extortion claim is based on Lively refusing to promote the film unless she was allowed to create her own cut. Lively demanded with extortionate threats that Baldoni and he support her PGA certification, and Lively and Reynolds attempted to force Baldoni and Wayfarer to read a statement apologizing for the film. Again, he's recounting Baldoni's version of events. He's not saying that's what happened. He's saying, assuming for this motion to dismiss, that everything that Baldoni is saying is true. It is evident the defamation claim is based on Lively, Sloan, and Reynolds providing the CRD complaint to the Times before it was released and stating to the Times in substance that the Wayfarer parties engaged in sexually inappropriate conduct towards Lively and retaliated against her for reporting the misconduct by engaging in a campaign to ruin her reputation. Sloan's and Reynolds making additional statements that Baldoni had committed sexual misconduct, and the Times stating that Baldoni, Heath, Abel, and Nathan had engaged in a smear campaign to ruin Lively's reputation. I agree. I do think it is a mess. It's not necessarily called out. I think we can get the gist, and I think that's what he's saying here, is it's enough to go for it. We get another dig where the amended complaint does lack clarity. The court will consider only the claims of which defendants have fair notice. To the extent that a fair reading of the amended complaint does not provide notice that the Wayfarer parties are making a particular claim against a particular defendant based on a particular statement, the court will not pass through the various allegations and documents to determine whether a claim could theoretically be stated. So just kind of pointing out here that, look, I'm going to give you a fair interpretation, but there's limits. And if you can't make a particular claim against a particular person based on a particular act, it's not on me to sort of figure out and invent what you're trying to make a claim against. It needs to be clear and simple enough that it is, this person did this against this person. Judge Liman throwing it in the trash. Yeah. This footnote was Liman saying, don't piss on me and tell me it's raining. For example, although the amended complaint alleges the CRD complaint was rife with lies and doctored evidence, the court will not consider whether the CRD complaint contained any defamatory statements beyond those specifically alleged in the amended complaint. So, again, as part of their amended complaint, they oftentimes throw out this hyperbolic language. Oh, it's rife with lies. Well, what lies? Well, we don't ever get that from them, and they do this a lot throughout their amended complaint. So it was nice to see Lyman kind of call this out, because that was one of my frustrations in reading, I think, like the original New York Times. It was very bombastic, hyperbolic. It was all of these things have been done, and you're like, where? I felt that was a big contrast between their complaint and Lively's complaint, which was very much this happened, then this happened, and pointed out where it was. All right. Similarly, in analyzing the defamation claim against the New York Times, the court will not consider whether any statements in the article are defamatory beyond those identified in the amended complaint. So I'm only going to pick up on what you said you were upset about. I'm not going to read through the New York Times article and say, hey, what about this one, right? I'm not going to do the internet sleuthing for you, right? I'm not going to be a mommy sleuth on behalf of Wayfarer, is what Lyman is saying here. It's like the Wayfarer lawyers are fresh out of law school. Honestly, there's a huge question that comes after this, I think, of just everything that's going on, because as much as I'm like, Brian Friedman is Brian Friedman, and Brian Friedman will Brian Friedman till the day that Brian Friedman drops dead, I don't understand how the other partners at Friedman, Liner, Tattleman, whatever, his entire law firm, sign off on this and let this go out the door. I don't. That is beyond me. The Wayfarer parties have an obligation to identify the statements which harm them, rather than gesturing at a document or category of statements and forcing the defendant to guess which ones are actionable. Not great. Not a great line to hear in here. And I think it kind of shows Lyman's approach and thinking to this, right? Not very impressed by it generally. And I think that's something else I didn't call out through this. There's a lot more, I think, reading between the lines here. Whereas, like, we're used to the pleadings that come from Lively and Friedman being able to freely say what they want to say and attack each other, Lyman, as the impartial judge, has to be more reserved in what he's saying. And so I think we saw this with, like, the motion to strike. We saw this with the motion on the protective orders. There's things in there that you have to kind of read a little more into. Now that's open to more to interpretation, right? Like this. This could just be a throwaway line that he's just saying, hey, this is general good practice, rather than he's specifically pointing a finger at the Wayfarer parties and saying, you got to cut this shit out. I feel like it's the second one rather than the first, but I mean, there's a valid interpretation that he's just bringing this up to talk about. I don't get a sense that that's what federal judges do, though. I feel like everything in here is in here for a reason, and if he calls this out, it's because he wants you to take note, and he's kind of dressing you down a little. Likewise, if the complaint uses the lively parties or the Wayfarer parties in a context where a particular plaintiff or defendant is not clearly indicated, the court will not guess at what claim the amended complaint is attempting to make. So again, I'm not going to do the work for you. Such a course would promote litigation by ambush, allowing plaintiffs to use vague pleading to hide their claims only to spring them on defendants in opposition briefing or at trial. He's saying everything has to be clear and upfront right now. It's not going to be vague, and then at trial kind of solidify, what we actually meant was. So, accordingly, though the court will not strike or dismiss any allegations on Rule 8 grounds, the court will only consider those claims that a reasonable defendant would understand to be asserted against it based on the allegations in the complaint. Full bench beatdown. Yeah, I mean, there's quite a lot of these as we go through this tonight. So civil extortion. So this was like their major first claim. This is the big part of Wayfarer's whole complaint against Lively was no. The sexual harassment didn't happen. This was all to service her taking over the movie and taking control, snatching all of this from Baldoni so that she could put in more hours, do more work, make her own movie, and then give Wayfarer and Baldoni the credit for all of that work. Somehow that is their story and injured her in some way. Oh, and then did so in a way that made $200 million for them as well. This is what they're complaining about. The Wayfarer parties' first claim is for civil extortion. In support of this claim, the Wayfarer parties allege that Lively refused to return to production unless the Wayfarer parties agreed to her production demands, and that Lively threatened to abandon her contractual obligation to promote the film or approve marketing materials unless the Wayfarer parties agree to co-funding a screening of her version of the film, eventually release that version, and grant her a producer credit in support of seeking the PGA designation. That Lively then threatened to boycott the premiere unless Baldoni was excluded. That Lively threatened to attack Wayfarer in the press if it did not take the blame for the problems during filming. And that Sloan carried out Lively and Reynolds' threats by spreading false allegations that the Wayfarer parties had engaged in or concealed sexual misconduct. Lively, Sloan, and Reynolds argue that none of the alleged acts are wrongful and that they did not obtain money or property from the Wayfarer parties. The Wayfarer parties argue that they are not required to allege a transfer of money or property and that the threats alleged in the amended complaint are sufficient. Lively, Sloan, and Reynolds have the better of the argument, pointing out that they are wrong on this. The Wayfarer parties also allege in several instances that they took actions desired by Lively because of her past threats or because of a general atmosphere of threats or fear. Specifically, Baldoni realized that after the return to production demands that he needed to cede control of the script to Lively, and the studio agreed in light of Lively's threats to do an official audience test of Lively's version of the film. These allegations fail to connect particular threats by Lively with particular demands, and it is at best unclear whether the Wayfarer parties are alleging that Lively threatened to take a particular action unless the Wayfarer parties gave her control or agreed to an audience test. So a big part of Wayfarer's complaint is they say, well, they feared that she would do this, and so they gave her this control. Liman's pointing out that you thinking she might threaten you and giving her something is not the same as her directly threatening and needing that. Lively does not have fair notice that the Wayfarer parties' extortion claims could have been based on such allegations. Assuming these claims were clearly alleged, they would nevertheless fail for the reasons discussed below. Neither threat constitutes wrongful duress as a matter of law, and the Wayfarer parties have not pled that ceding control of the script resulted in damages. Again, their movie made $200 million. Like, I don't understand. He talks about the governing law in here. And then there's quite a bit of this. The parties advance different understandings of the tort of civil extortion under California, and talking a lot about, do you actually need money or property back from it, and talking about a lot of the case law for it. I'm not going to dig into this because it is a lot. And there's quite a bit of this in here. I mean, it's probably really interesting if you are into law. I am not. I will assume that somebody this well read understands what they're doing. And he says here, for the same reason, Lively's argument that the tort should be limited to threats of litigation is unavailing. So this idea that they were going to threaten to sue for, sexual harassment if they didn't comply with what she was going to do. And talks about, although, where is it? He talks about the reasons why it doesn't stand, I guess. Again, I don't understand, because he's talking here about the threat of litigation and then talking about other pieces, unless he's talking specifically about the case law that they cited. I don't necessarily know. All right, keep going, because like I say, I don't necessarily know. More of this. I think I go all the way to 59. I don't think there's anything in here. So this is the point. The Wayfarer parties can argue to the contrary that a plaintiff can recover for civil extortion even if no money or property was obtained. This was their case law that they cited. I remember Monex. And then he goes into explain all of that. But essentially, he argues instead that Wayfarer basically misunderstand civil extortion. They are doing it on the criteria for criminal extortion. All of that was to basically kind of explain the difference between the two requirements to be able to plead civil extortion. And he says here, accordingly, to plead a tort claim for civil extortion under California law, it is neither necessary nor sufficient for a plaintiff to plead the elements of criminal extortion. Instead, the plaintiff must plead a wrongful threat constituting duress to which the plaintiff acquiesced, causing damages. He's saying no, the civil extortion elements are much higher, and you do have to show the threat, show that you complied with the threat, and that there were damages that you resulted in it. The Wayfarer party's civil extortion claim is based on allegations that Lively refused to return to production until the Wayfarer parties agreed to her production demands, that Lively threatened to abandon her contractual obligation to promote the film unless the Wayfarer parties agreed to co-fund a screening of her version, eventually release that version, and grant her a producer credit, that Lively threatened to boycott the premiere unless Baldoni was excluded, and that Lively and Reynolds threatened to attack Wayfarer in the press if it did not take the blame for problems during filming. The last set of allegations is not actionable because Wayfarer did not acquiesce in the threat and did not they did not accept blame for problems during filming. Wayfarer did not lose anything, and Lively and Reynolds did not gain anything from the threat. So again, Liman points out that and I'd made this, I think I talked about this point before, is that he was suing for extortion and saying, oh, we couldn't tell her no. And yet every time he tells her no, she's going to, not go to the premiere. They're going to boycott the premiere if Baldoni was, if he was allowed to attend. Baldoni was still allowed to attend the premiere. Wayfarer worked out a solution in which Baldoni went by himself and then got the cast to go. So her threat of we're going to boycott if Baldoni goes didn't work because Wayfarer kind of negotiated a compromise. The whole threaten to, sue you if you don't put out the press statement. They didn't put out the press statement. So if you're going to claim extortion, you have to, you have to accept the threat and agree to it. And lose something in damages is what he's pointing out. The actual just threatening to do it is not enough, at least on the civil side, for extortion. Junk Farm says, my understanding of extortion is threatening to do something illegal. Breaking a contract is not actually criminal. If she breaks her contract, that's literally what insurance and civil court's for. Yeah, and I think, like I said, if you go through, I read through, I'm just not doing it on stream, all of this. case law around it. I think he makes the point of that there are some extortion claims where like the threat of extortion is enough. It's not enough in a civil extortion claim, which is why he's calling that out. In a civil extortion claim, there has to be a clear threat, constitute duress, you have to agree to it, and it has to cause you damage. There has to be an impact. And he's missing most of the elements of all of that in his claims of extortion. He's just saying, well, she threatened. Okay, she threatened. It doesn't rise to criminal extortion, and it's not strong enough for being civil extortion. Okay, the remaining allegations must be dismissed because the allegations regarding Lively's wrongful threats are conclusory and fail to support that the threats were wrongful. In addition, the Wayfarer parties have failed to plead that several key instances of alleged extortion caused actual monetary loss. So even if they agree and she threatens, it didn't actually impact them or cause a damage from which they are open to relief from the court. Talking about the demand to issue a press statement, but the Wayfarer parties never issued any such statement. Accordingly, there was no reliance on the threat, and the Wayfarer parties did not give up anything to Reynolds or Lively, and the plaintiff did not sustain damages cognizable in a cause of action for duress. The Wayfarer parties allege that in response to threats that Lively would stop acting in the film or breach her contractual obligations to promote it, they were forced to agree, give Lively even greater control of the script, gave her a producer credit, and accept marginalization for the premiere. However, Wayfarer does not plead sufficient facts to support an inference that these threats were legally wrongful. Lively did not make a threat to physically harm the Wayfarer parties or the property, nor did she threaten a false lawsuit. Talked about the complaint alleges that Lively subsequently followed through on a threat by providing false information about the Wayfarer parties to the Times, but that conduct is actionable, if at all, under the law of defamation and not under the law of civil extortion. It does not support an inference that the Wayfarer parties gave anything to Lively or that Lively obtained anything from them by virtue of the threat. Again, this is an attempt to control her behavior, and we've talked about this from the beginning, right? They are upset that they couldn't control her, but they also didn't want to give in to her demands. So they didn't want to deal with the consequences of her saying, hey, setting these boundaries. If you don't do this, I will do this. And then saying, well, she did it. Yeah, she told you she was going to do it. The Wayfarer party's claims do not turn on what Lively threatened to do, but what she threatened not to do. And again, this is what I talked about, like her not participating in the premiere, her not doing promotion with Baldoni, was her setting a boundary, and it's different than her saying what he can and can't do. And it's part of why Wayfarer in their complaint spun it around to like, oh, Baldoni couldn't attend his own premiere. Like, no, that's not what they stated. What they stated was, if he shows up, we won't. We're not saying what he can do. We're just saying that if he's there, I'm not going to be, which is very different than what they alleged he threatened, which was he's not allowed to be at the premiere. The Wayfarer parties allege that Lively threatened to refuse to promote the film or approve any marketing materials, and threatened to abandon her contractual obligations to promote the film or marketing materials. However, the Wayfarer parties do not allege facts showing that Lively had an obligation to promote the film or to approve the marketing materials. They do not point to any contractual provisions, explain what Lively's contractual obligations were, or even explain what the contract is being referenced. And we had talked about this as well through this case. They continually pointed to saying that, well, she wasn't going to do this, she wasn't going to do that. And if she had a valid contract, they would very easily just be able to attach that to their complaint and say, here's the contract that said that she had to do this, and she didn't do it, she broke her contract. Very simple thing to plead. And they didn't do that, which suggests there wasn't a contract. And we'll also get into that later, I think, as we talk about the employment contract. Liman makes that point too later on to say, actually, Wayfarer kind of sort of admit she didn't have a valid contract. If you do X, I won't do Y. Not give me X or else I'll do Y. Yes, says Master Jinx. Exactly. That's the distinction that he's making here. Obi-Wan Kenobi says, oh no, he was there. They just didn't want to walk the red carpet with him. He's such a liar. Yeah, I mean, like, he was, and again, it was Wayfarer's idea to do the whole separate premiere thing and have the separate screenings as an alternative to having the entire cast boycott the premiere, because it would look really bad, and then they would have to explain why none of the cast want to be around him, which ultimately they still end up having to explain. Did Baldoni say she didn't sign the contract? Yes, Obi-Wan Kenobi, and we'll get into that in a little bit. I think that's a little bit later on. I think that's way later. But similarly, with regard to Lively's refusal to attend the premiere, the Wayfarer parties do not allege that Lively had any obligation. Wayfarer parties plead that Lively had an obligation to act in the film. They do not allege that she had such an obligation, no matter the circumstances. And this is a big deal, right? A refusal to provide that which one has no obligation to provide is not a threat. It's a bargaining position. So Liman specifically calls out here that none of this rises to the level of extortion. She wasn't obligated to do or perform these services. Her saying that she wasn't going to do them unless I get X or Y is just her negotiating. It's not extortion. Conclusory allegations are insufficient to plead a breach of contract, and therefore are insufficient to plead that Lively threatened to breach her contract. So again, this is where we'll get into later. He talks about you need to bring up the contract. In order to prove this out, we need to see that contract to see if you have a claim here. With regard to the PGA credit, the Wayfarer parties simply allege that Lively demanded they support her PGA certification with extortionate threats. The failure to specify what Lively purportedly threatened is fatal to any claim based on the allegation. Again, talked about this a bunch of times with his complaint. Number of times he shows all of these text messages. Here's her wanting to, invite him to the trailer. Here's her talking about probiotics with, her trainer. Here's her doing all of this stuff. The moment that it becomes, and then Lively threatened, there's not a single text message. There's not a message between any of them. There's nothing. And Liman calls that here. We have no idea what she threatened in any of the circumstances, but especially with regards to the PGA credit, they just say that they gave it to her. But we've never seen anything from Lively threatening anything. Even with the premiere, they just say that that's what happened. We don't see an email or any understanding of, hey, if you don't do this, she's not going to. Lively's contractual obligation to continue acting in the film is unclear. The complaint emphasized in several places that Lively had not signed relevant employment contracts and never explains what contract Lively did sign. So they try and infer that, hey, she was obligated to do these things, but they don't. They don't have to say it. And I think, again, this gets brought up later, if I remember rightly, because he talks about her holding off signing in order to get something else. Moreover, assuming the Wayfarer parties did plead that Lively refused to do what her contract required to do, that would not alone be sufficient to plead that such a refusal was wrongful and could support a claim for civil extortion. A threat to breach a contract may constitute a breach of contract or an anticipatory repudiation of a contract, but it is not of itself improper. So he goes on to say, look, there's circumstances where in the execution of a contract, one party realizes that there is a term agreed to on the contract signing that is no longer in the best interests of both parties and seeks a modification. It is thus not uncommon in commercial relationships that the other party will demand a condition to their agreement change before performance is rendered. A refusal to perform unless the counterparty agrees to additional consideration or new term may, depending on the circumstances, give rise for a breach of contract. But if the other party finds the modification to be acceptable, either because it's in the mutual interest of the parties or because the modification is not so significant that the counterparty believes she is denied the benefit of her bargain, she can accept the modification either by words or by conduct. So basically he goes on to say, it follows that not every statement that a party will stop performing a contract unless the conditions are changed will give rise to a claim in tort for civil extortion. Saying that, look, just because Lively said, hey, I'm not going to act and not come back to production unless, doesn't by itself rise to civil extortion. To allege the civil extortion claim, the Wayfarer parties must allege facts supporting the threats were unrelated to or disproportionate to the obligations Lively had assumed in her agreement with the Wayfarer parties, and the Wayfarer parties had no adequate remedy and could not have refused her demands. The facts alleged do not support an economic duress claim. The Wayfarer parties first alleged that Lively threatened to stop acting in the film unless they agreed to her return to production demands. The court assumes, though it's not explicitly pleaded, that Lively had a contractual obligation to perform in the film. Again, pointing out that it would have been really helpful to your case to have provided her employment contract, the actual contractual obligation she had signed, be it the loan out agreement, be it her employment contract, whatever it is that she signed, we would need to see it, but they don't. The Wayfarer parties do not plead that she had an obligation to perform, no matter the circumstances on set. And it's not unusual for employees to seek changes or improvement in workplace conditions. Likely there is, even if there is some sort of employment contract, there is going to be something about it needs to be a safe environment. So the kind of asks that she was asking for with her return to production are going to be covered more than likely by her contract. And I suspect that's why we've not seen it. Whatever contract there is, there's going to be something about, we reserve the right to not perform or hold back performance if it's not a safe environment for the actor or something like that. I cannot see it not being the case. It is kind of like a bedrock of like employment contracts and laws that like, they have you a right, like you have a right as an employee to have a safe working environment and they have to provide it. I just don't see that not being in there. Junk Fam says, I mean, the amendment they signed to stop harassing her is a breach of contract in Baldoni's will, then don't sign it. I mean, every lawyer that I've heard to that has like looked at that 17 sign return to production has all said, I can't understand why they ever signed this, because they're trying to say they never knew about it and it was not an admission of guilt. Everything in there drips with admission of guilt. The fact that Sony are telling them, hey, we want to accept this, but not accept the underlying claims, right? Because it looks bad. The fact that it says in there, there were multiple productions on set from pre-production that, we want to have a safe working environment. So we're going to put this out here. And if you don't agree to it, we will seek legal action. Like all of that is really bad and doesn't say like, hey, Lively had some ideas of how to make the set better, which is what they are trying to claim. It's crazy that any lawyer would have let them sign that. And I don't know what legal counsel, well, we do. I was going to say we don't know. We do know what legal counsel was on the film and advised them and helped them with that. They should never have signed that. I mean, honestly, if Baldoni's telling the truth, they shouldn't have continued, to work with her. They should have fired her and hired another actress. If she was this demanding and terrible and inventing all of this stuff, I mean, that would have been the way to go, but they didn't. And I think that's largely because he's not telling the truth. The demands Lively has alleged to have made, including there be no physical touching of her except in connection with her character or scene work, that there be no discussion of personal experiences with sex, and that she have a personal representative on set, there be a nudity rider, are all closely related to the conditions of her own performance and largely involve adherence to protections for Lively and other cast members that the Wayfarer parties had already implemented, right? Part of it is, Wayfarer say, oh, we agreed to all of these things because we already had them in place. No, that's not quite true. They had hired an intimacy coordinator, but they weren't on set all the time, which is what Lively had asked for. They did have a closed set protocol, but it was not as extensive as the one that Lively had asked for, where, it was closed down to non-essential people. Wayfarer kind of fudge around what they mean by essential workers, but it also was still being broadcast on monitors, and there were still visitors to set, right? So not a typically closed set as maybe Lively would expect it on other professional sets. Now, Wayfarer, in their defense, like said, well, we already were doing a bunch of those things. So it can't be both ways. It can't be this extortionate claim where she's making these demands, causing this duress and undue financial burden on Wayfarer, if you were already doing those things, right? If the things she's asking for, don't touch me, right? Don't talk to me about sex. Don't show me nude imagery. Have an intimacy coordinator said, like, if these are all things that you're like, yeah, no, we totally did that because we like a safe environment, then how is her asking for those things this extraordinary, unreasonable demand? It should just be, yeah. Interesting to hear that Liman called that out. I mean, I think we talked about that a couple of times. So the only apparent cost to the Wayfarer parties was hiring an additional producer, which would not financially benefit Lively. I mean, I've talked about this so many times about her 17 protections don't really benefit her. Here's the point where she could say, I want directorial, control. I want to be editing the movie. I want to rewrite the entire script. I want to, approve everything and all of the marketing. Like, this was the point. If they're saying they were so terrified that she would falsely accuse them of sexual assault, I mean, go big or go home, right? Like, what did she ask for? She asked for the Sony rep to be present on set every day. She asked for an additional producer to be on set every day to supervise safety. She asked that Alex Sachs be more empowered to be able to make decisions and have her opinion taken and considered seriously. Like, how is this increasing Lively's power? All of this was about benefiting the whole cast and empowering other people to be in control of protecting the set, not Lively herself. Worst extortionist ever, says Mousy. Honestly, I think part of this, somebody needs to sit down and explain to Blake Lively what extortion is, because she clearly missed the memo of how to properly extortion somebody. I, however, have learned how to extortion somebody, and so I will repeat. I'm doing this for Lively's cupcakes. So once more, cupcakes. This is why I'm doing this. So at some point, Blake Lively cupcakes. The allegations do not support that Lively was attempting to extort the Wayfarer parties into hiring a producer, as opposed to seeking to confirm previously understood terms and conditions, or at worst, seeking a slightly more favorable term of employment. So Liman also makes the point here of like, all of this was like creating a safe environment. So all of this was in kind of service of doing what should have already been part of her contract of having a safe environment. Junk Farm says, yeah, when I read the demands in the CRD, that ticked me off, because literally nobody should have had to ask. Every one of those things should be assumed from any job. 100%. And I still drives me nuts that anybody talking about the birth video is like, well, it was a birth video. She hadn't, well, she's being upset. She's had kids. Like, there is no world in which you show somebody a video of your wife, nude, birth or otherwise, without saying, hey, I have a video I would like to show you. Here's the contents of that video. May I have your permission to show you that video? You don't just play it and then throw it in somebody's face and be like, hey, hey, do you want to see my wife nude? No, never. And this has to be explained, or at least that this is not the reasonable understanding of that situation. That everyone's like, whoa, she's being unreasonable. Like, I don't understand at all that this is not Mad Men, right? Like, this is 2025. This does not need to be explained. Even if they turned out to be unneeded, as an employee can insist on protections at workplace for sexual harassment without being accused of extortion. If an employer agrees, it cannot later claim to be a victim of the employee's wrongful threats, pointing out that they signed the document, they agreed to them. They put these protections in place. Although the Wayfarer parties allege that this list was drafted for the apparent purpose of insinuating or outright claiming that Baldoni, Heath, and others had engaged in sexual inappropriate conduct, there are no allegations that Lively threatened to reveal such behavior if her demands were not met. Again, every single time that they allege that Lively threatened something, the texts and receipts dry up. That well is gone, is spent. There's not a drop of receipt from it. And Liman again pointing out that where is that? A similar result applies with respect to Wayfarer parties' allegations that Lively threatened to breach her contractual obligation to promote the film unless they allowed her to edit the movie, release her cut, give her a producer credit, and supported her in seeking the PGA mark, and co-funded a screening of her film. These demands do not disproportionately involve a disproportionate exchange of value, as Lively insisted on taking on additional work for no additional pay. They bring up the point that she had made in her motion to dismiss, saying that at best, Wayfarer alleged that, she gave more. They don't allege that she wasn't, as producer, allowed to be involved in the edit of the movie, or to have a say in promotion of the movie, or, to take on those roles. They simply argued that she did too much of it, and they would rather she didn't. And they said, if anything, they're arguing that she did a bunch of free work for them without charging them more for it. Ossan just says, footnote 32, you can't just argue it's the vibes. yes. I would I would think at first it might be gone. Yeah, no, I would, I would, I would agree. Everybody would at the first glance. There's no reasoning a work employee should be showing it. And I think again, I've talked about there's layers to it as well. Like for these men who understand these conversations supposedly and having this as their platform, again, in their place, right? It would be wrong to ever show somebody personal to me, especially my wife or a family member or anybody in that situation. And if I was wanting to explain to Blake Lively how to film this scene, how we wanted to do it, or that we had this idea, you would look for non-personal examples. You would look for, videos on the internet. You would look for other movies that are shot in a similar way and say, hey, this is the artistic look that I'm going for. These are the comps I'm going for. I used to do photography, and a part of that is like creating these image boards and saying like, hey, this is how we want to shoot. This is the look we're going for. It is not, getting somebody close to me and personal to me to like wear a bunch of lingerie and be like, hey, I want to shoot this lingerie like this. Like it's just crazy to me that these men don't understand how wrong it is to be taking a personal video of your wife and using that at work to demonstrate to an employee how you want to shoot a scene in a movie. And everyone's like, oh, no, it was just innocent. Like, there's nothing about that is like innocent. It is loaded with context that, again, men in this space with this platform should have clearly understood. I don't. Our sentence says, from many who understand these conversations, supposedly error, evidence not found. Fair, right? Like we're all learning, but I think that for me is part of like that evidence that shows they never got it. It all was a fraud. Everything was fake, because there's just no light that goes on, no neuron that fires that, oh, crossing boundaries here. And again, I don't know how anybody in this space reading these books, learning from other content creators, being educated on this stuff, doesn't have that context or understanding. And they just presume that Blake wanted to see that while eating lunch with Master Jinx. Yeah. Agreed. And Amobi Mom Kenobi, what sane, rational person thinks this is okay? What man thinks I'm going to show this woman I barely know these videos of my wife nude? Agreed. None of it makes sense to me. There's also no allegation that Lively had a contractual obligation to promote the film. Again, if not, there is no basis to assume that the value that she conveyed in terms of her willingness to promote it represented anything other than a fair trade for the Wayfarer party's willingness to use her cut. So here Liman makes like an additional argument to say, look, if she didn't have a contractual obligation to promote the film, which it very much seems like, and I think he will get into that. I keep saying he's going to get into that. I forget whereabouts this is, but I think he gets into it. Because I'll just say it. They were talking about getting her to sign the employment agreement, noting that if she didn't sign she's threatening to not promote the movie, if she not sign the contract agreement. And so they were trying to appease her to get her to sign the employment contract. So Lyman's saying, look, if what you're saying is true, and she didn't at that time have a contractual obligation to promote the film, and you were trying to give her what she wanted in order to get her to sign the employment contract so that she would have a contractual obligation to promote the film, then she's offering something of value and not getting anything in return. So if anything, this negotiation is her just kind of getting something in return, a fair trade. I don't have to promote your movie, but I will put in the time and effort and promote your movie for some sort of compensation, right? That's what he's saying. Non-monetary compensation. There are other things you can give me. Her demands were related to the subject matter of the contract. As Lively sought to have the film she would be promoting fit her vision, saying, I'll promote the movie if I get a say and more creative control over what that movie looks like. And again, he's just basing this off what Baldoni has said in his complaint. Although Wayfarer parties alleged they did not believe Lively deserved a producer credit, they also alleged that Lively took over significant production responsibilities, which, oh my gosh, how many times have we all made this argument, right? That she didn't deserve a producer credit, but she also took control of the wardrobe, took control of the script, changed a bunch of scenes, edited the movie, released her own cut of the movie, and also apparently significantly built relationships with the cast members to the point where they all turned on the director. She also took over the media for the movie, doing all of the digital content and promos that she did with Isabel Ferrer and Blake Sklenar and Colleen Hoover, where they're making cookies and doing all of the stuff that they did on the Instagram. So she did all of that, but also she didn't deserve a producer credit. Again, so he's pointing out like the contradiction in their claim. The Wayfarer parties have not alleged that Lively requested changes in production for some purpose unrelated to the contract. The amended complaint alleges that Lively believed her version of the film to be better than the version favored by the Wayfarer parties, and that her efforts deserved recognition. So again, he's taking Wayfarer's best interpretation of the story, but also explaining that, look, even if we take your version of the story, understanding where Blake Lively was at, you're not making a good claim here, right? There's nothing here that shows she was acting maliciously or evilly. She was just negotiating. The amended complaint is not clear whether the Wayfarer parties, as opposed to Sony, had the ultimate right to choose the cut of the film that would be distributed or the marketing plan that we used to promote the film. There are indications from the amended complaint that such rights resided with Sony. Blake Lively's motion to dismiss brought this point up, that they are complaining that they didn't have editorial control and be able to release their cut, but they have never shown that they had that right, that they had the right to release their version of the film, Justin Baldoni's edit of the film. And again, we haven't seen the contract between Wayfarer and Sony to know whether that is true or not. There is a good chance, given that Sony picked this up as a negative pickup, that they did so, ultimately reserving the right to control the cut of the movie. Because what you don't want is to say that, hey, I'm going to pay 50 million, 100 million, whatever, for a movie, have somebody else go make it, and it be terrible, and you just have to put that movie out. It is very likely that, given that they were putting in this money, that they wanted some sort of control creatively over what was released. Again, we have not seen that contract either, so we don't know. So he talks here about Sony allow her to create the control of the movie, pointing it out. If so, Lively would not have been withholding from Wayfarer parties anything that Wayfarer parties had a right to obtain from her in the first place. She didn't steal their cut of the movie. They never had a right to a cut of the movie. Sony allowed her to make a cut, right? But even assuming the Wayfarer parties had such a right against Lively, they were not without a remedy. If in fact Lively announced she would not perform unless the Wayfarer gave something of value to her to which she was not entitled, the Wayfarer parties could have sued. They could have. And again, I think this point has been brought up so many times. They didn't sue until she sued them, right? That's all of a sudden of, oh, actually, I didn't make that movie. That movie was Blake Lively's movie, and she was terrible all throughout production. We just wanted to be nice about it and not say anything. They were not without a reasonable alternative to meeting her demands. So they weren't forced to do as she said. Although the Wayfarer parties state that Baldoni was forced to choose between killing the film and his own career by insisting on his own creative vision and rights, at the point these threats were made, filming was complete. If the Wayfarer parties had the right to put out a film with Baldoni's edits in the first place, they were not without the ability to do so as a result of Lively's demands. As in, you can let her go play and edit the movie, but if ultimately you have the right to put out the film with your edits, you could have still done that regardless. That they didn't, again, I think very significantly shows that Sony had control over it. The only loss would have been Lively's promotion of the film, but there is no allegation regarding Lively's obligations to the Wayfarer parties regarding the promotion. And even if there were, although the film might be less profitable without Lively's promotion and efforts, the desire to avoid a loss in profits is not the same as duress within the meaning of the law, saying that they didn't do it under duress. They were just doing it under, like, it wasn't their preference, and that's not enough to meet the claim that they're trying to make. Let me see. Gina Richards says, I thought she was a producer from the very beginning. Yes, executive producer. Producer and executive producer, I think, as our scientists are saying, they're different, and they have different roles. Producers are much more hands-on, and actually helping with the production of the movie. Executive producer is more of like a vanity title given to you for helping and acknowledging your help in the movie, but not necessarily with a bunch of roles and obligations. Marcy Jinx says, I don't think Baldoni or Heath thought about how their actions impact others. They think their good intentions equal good actions because they don't think critically about their gender. Yeah, agreed, Marcy. And I think that's a huge conversation that needs to happen, I think, with a lot of, particularly men, and myself included, right? When you're in this space and existing in this space and interacting with people who are advocates and just people generally, you can do a lot of harm while trying to do good. I have learned that as well over 3 years, so I have to think a lot longer about my actions. Los Angeles also says, I love how Liman is pointing out they're suing the wrong person here. Yeah, they should be suing Sony, is what he's telling them. The fact that a plaintiff decides it's more financially beneficial to acquiesce to a demand than to sue does not mean the plaintiff lacks an adequate remedy in damages. Having made their decision, right, that they were going to agree to her demands and not sue, the Wayfarer parties cannot now seek to recover in damages for what they would have attained had they not agreed and had Lively promoted some different version of the film more consistent with the Wayfarers party's artistic vision. So again, arguing that, look, if she threatened to not promote and do all this damage, you could have sued her then and then. You don't get to agree to her negotiation and then try to sue her for what could have been. Finally, the Wayfarer parties allege that Lively's threat to boycott forced Baldoni to accept marginalization from the premiere. Initially, the Wayfarer parties do not allege that Lively had an obligation to them to attend the premiere, much less to attend the premiere with Baldoni. However, even if she did have such an obligation, her suggested modification is directly related to the conditions of her own performance. There is no threat intrinsic and unrelated to the production of the film. So again, her saying, I'm not going to be there if he's going to be there, is a modification about her conditions, not about, hey, I'm going to threaten to, expose you or damage the film or whatever. There is no disproportionate exchange of value, as the separation of the parties at the premiere is not alleged to have had any financial implications. Again, the only issue was that there was talk about what Baldoni had done. He didn't like it. And again, the movie made $200 million. So good luck. Lively, Sloan, and Reynolds also argue that the Wayfarer parties have not alleged damages from any of her threats. For reasons largely stated about in the analysis of disproportionate value, this provides an alternative basis for dismissal of most aspects of the extortion claims. So again, already given all of this other reasoning, and now on top of this, this is also on top. So again, layers and layers and layers. None of them are really good enough to survive dismissal. Messaging says they don't even allege that Ryan Reynolds tried to buy the rights. Freeman just hypothesized that perhaps. Oh, I mean, like that whole nonsense and like the morality clause that got invented through the whole thing. It's crazy to me. It's a lot of things. All right, checking my notes here to see where we are at. I think I've read through most of this, so I don't think I'm going to miss anything along the way, but I just want to make sure. The court assumes that without deciding that an extortion claim could be based on the transfer of creative control if, as a result of such transfer, the plaintiff lost something of value for which it did not receive equivalent or greater value in exchange. However, the Wayfarer parties have not alleged that Lively's editing or the eventual release of her cut of the film caused them monetary loss. Although the Wayfarer parties preferred Lively to take less of a role in the production of the film, they do not allege that it made less money due to her editing or that the role resulted in costs to them. Again, made $200 million, so good luck making that argument. As noted above, the Wayfarer parties allege they were financially damaged by the agreement to return to production demands and agreeing they co-funded screening of a version of the film. These aspects of the claim are dismissed only due to their failure to allege a wrongful threat. So here they at least show some damage, but again, they don't actually show any threat. Again, missing a key piece of their case. So we don't even get to whether it should stand on like the law. He's just saying it just wasn't even properly pled. There's nothing in there. The Wayfarer parties allege that civil extortion claim may only be based on the transfer of money or property, but he kind of comes back on that and says, however, there's no principal reason that it could be just limited to money or tangible property. Wayfarer possessed the film rights and therefore had the right to control the film, what would be produced and released. Had a party demanded at gunpoint the Wayfarer parties employ a novice to edit their film and this caused the Wayfarer parties damages, the Wayfarer parties might be able to bring a civil extortion claim. So he's also calling out some of the arguments that are being made by Lively in the motions dismissed and so pointing out where like, yeah, I don't really find that convincing either, such as in this one. I don't see it myself, but I don't know. I would imagine, you know, it's extreme there, demanded at gunpoint. At what point would that be the case if like Sony had asked Wayfarer to put Blake Lively and edit their film? Does that not also count? Because Lively has, I don't believe, directed or, well, no, she might have directed, but like, you know, she might not be as experienced a director. So I don't know where the line is there. That one seems quite blurred to me. I get he's making a much bigger claim here, or an example, demanding at gunpoint and employing a novice, right? But I mean, there's got to be a line somewhere. I don't see it. Accepting the allegations, Wayfarer gave up on releasing its preferred version of the movie, cut by Baldoni in favor of a version that Lively preferred, but there's no allegation that Baldoni's version of the movie was of greater value than Lively's. For that independent reason, the Wayfarer party's civil extortion claim related to the demands for creative control fails. Similarly, although they allege the conditions of the premiere were demeaning and humiliating, they do not allege any cost to Wayfarer. There are no allegations supporting that providing Lively with a producer credit resulted in any loss to them either. The injury that the Wayfarer parties focus on regarding the PGA mark is essentially a moral injury. They believe that Lively did not perform the duties of producer and did not therefore merit the PGA mark, but were forced to write a letter admitting the truth. Finally, there are no allegations supporting Reynolds or Sloan's liability. The Wayfarer parties argue that Sloan and Reynolds are liable in conspiracy because by actually spreading defamatory statements, Sloan and Reynolds played the role of the heavy in carrying out the extortionate threats. However, the only instance in which Lively and Reynolds allegedly threatened to spread defamatory statements was in demanding the Wayfarer parties make a harmful statement, which, as stated above, the Wayfarer parties never provided such a statement, so no conspiracy related to the statement is actionable. In addition, if Sloan and Reynolds actually spread defamatory statements, they would be liable in defamation, not civil extortion. Finally, the Wayfarer party's allegations regarding the purported conspiracy to commit civil extortion are entirely conclusory. The Wayfarer party's claims for civil extortion must be dismissed. So, a ton in there. And again, I appreciate the nuance of him not just taking like the main cause of action, but actually going through each of the separate instances. And again, it's my first experience reading like this from a federal judge, so I'm sure this is what is normally done. But again, this is a lot of different pieces and moving parts to think about. So when writing a complaint as a lawyer, like this is a lot. This is why you would think it through. And I think this is why their claim failed, because ultimately they did kind of sort of slapdash throw it together in response in order to be able to put something out as PR of, oh, we're throwing something back at her. It'll be interesting, given that Freeman's saying that he is going to continue, if they put more thought into the next one, if they actually do bring something that considers all these moving pieces. Don't know that it necessarily will, but we will see. Okay, so we'll move on to defamation, cause 2. Told you it would be long. We're an hour in and we're through the first cause. But the good news is we're almost halfway through. So, Mokumuk says, now I must eat the tacos. I'm later to catch up. Enjoy the tacos. I hope they're really, really good tacos and you have good salsa to eat them with. Enjoy. Jack Bram says, the other thing that blows my mind is they supposedly, Ryan Reynolds tried to buy him off. They could have gotten an NDA and a fat check. If it's true, I mean, at this point, I don't even know how much I believe anything that comes out on PR statements. Rather, they could have bailed out at any point. Yes, they could. And I think that's the thing to me, is they could have just issued the statement. The statement itself wasn't that bad. The statement just said unspecified mistakes during production. That would have been far less harmful to his reputation, to Wayfarer's reputation, than this lawsuit. When looking at what they could have done, I don't know why they went this way. I mean, it seems like Melissa Nathan was encouraging going scorched earth, and maybe that's why. I do wonder if they regret that and not just taking that press statement when they could have. Obi-Wan Kenobi says Liman pretty much just smacked him, slapped him, and sent him back to mama. I mean, that was a lot. I mean, how much of that is all of the civil extortion? 47. So that's like 13 pages on just on the civil extortion. All right, defamation. So he starts out by talking about the background for it. They're bringing defamation claim against all defendants. So New York Times, Leslie Sloan, Ryan Reynolds. The alleged defamatory statements are to the effect that the Wayfarer parties engaged in, permitted, or failed to prevent sexually inappropriate conduct towards Lively, and the Wayfarer parties retaliated against Lively and others for reporting on alleged sexual misconduct by propagating false and misleading narratives about Lively. The Wayfarer parties allege that Lively, Sloan, and Reynolds engaged in a conspiracy to spread these defamatory narratives to the Times, other media outlets, and Baldoni's agency, and that the Times committed defamation by publishing the same narratives. These allegations all fail to state a defamation claim. So he comes in to basically say, okay, here's the legal definition under California law. The tort of defamation involves 1, a publication that is false, defamatory, unprivileged, and has a natural tendency to injure or causes special damage. He also argues that, where are we? I think it's a little further on. Talks about truth being a complete defense to defamation. The state of mind is necessary to support a defamation claim depends on whether the plaintiff is a private figure or a public figure. If the defamatory statement concerns a private figure, the standard under California law is whether the defendant acted negligently by failing to use reasonable care to determine the truth or falsity of the statement. Basically, if you don't know that it's true, that would count as defamation, right? If you just repeated something you heard and it was bad, you don't get to kind of say, well, I believe it. For public figures, that goes higher, and it has to be the standard of actual malice, which I talked about at the beginning. Actual malice doesn't necessarily just mean I don't like the guy, right? Actual malice has to be intentionally saying something you know to be false. They enjoy significantly greater access to channels of effective communication and hence have a more realistic opportunity to counter false statements than private individuals, which is why there is that higher level of libel, like higher level bar needed to be doing it. Applying the actual malice standards to figures allows the freedom of speech and press, that breathing space essential to their fruitful exercise, while also protecting private, citizens and saying that you don't just get to make up lies about them. Where are we? Statements constitute libel per se when a listener could understand the defamatory meaning without the necessity of knowing intrinsic explanatory matter. In such a case, the damage to the plaintiff's reputation is conclusively presumed and he need not introduce any evidence of actual damages in order to obtain or sustain award of damages. Essentially, if it is so bad that it just automatically would damage your reputation, things like saying that he's a sexual predator, right? Libel per se, damages per se, right? Like that you don't need to prove damage. It's just assumed that, yeah, that's bad and it's designed to harm the reputation. But if understanding the defamatory meaning requires knowledge of specific facts and circumstances extrinsic to the publication, which are not matters of common knowledge, a plaintiff must plead special damages that he has suffered in respect to his or her property, business, trade, profession, or occupation. So if it's not automatically so egregious that it definitely would cause damage just by the statement itself, you have to show how it would damage you. He talks about the California law and about 41.7. but he also talks, here I think in adding the 47.1, the legislation was a response to Me Too. He acknowledges, like the stuff that we're talking about with the amicus briefs and stuff. However, he will go on to later say that really wasn't considered. The Wayfarer parties allege generally that Lively, Sloan, and Reynolds worked together to advance a fabricated narrative in the press, and the Wayfarer parties had sexually harassed Lively, embarking on a calculated and malicious smear campaign to destroy her reputation. This allegation has multiple facets. Most prominently, the Wayfarer parties allege that Lively, Sloan, and Reynolds worked together to spread a false narrative to the Times, and in addition, the Wayfarer parties allege that as part of the same conspiracy, Sloan and Reynolds individually made false statements about Baldoni to other press outlets and Baldoni's agency. Scrolling to my notes. Lively had also made the argument about statute of limitations, that since the origin of the defamation claims were the CRD complaint, which were the 17 protections for return to production, that the statute of limitations had run out on them. Liman points out that that's not true, and that under the standard that actually them kind of reprinting or putting them out, claims of sexual retaliation made in different words to different audiences at different times don't constitute a single integrated publication. So it's a separate publication. Therefore, the statute of limitations argument does not apply. So again, kicking out another one of her arguments there. The Wayfarer parties have not adequately alleged a defamation claim as to any part of the purported conspiracy. They have not adequately alleged that any false statements were made to the Times other than the statements in the CRD complaint, which were privileged under California law. There's no allegation that the distribution of the CRD complaint was made by anyone other than Lively, but, Friedman, who sent it to the TMZ, or more particularly with the involvement or agreement of Sloan or Reynolds, right? They haven't shown that they were part of it. The Wayfarer parties have not adequately alleged that Sloan or Reynolds individually did any more than repeat Lively's version of events, which they had no reason to doubt. And he'll hammer on this quite a bit. And the Wayfarer parties have not adequately alleged that Lively should be responsible for Sloan or Reynolds' statements. The allegations of a conspiracy between the parties are conclusory. Where are we at? 80. The Wayfarer party's claims of defamation against Sloan are based on Lively, Sloan, and Reynolds, based on allegations her team made false statements to the Times. A fundamental obstacle to this claim is that the Wayfarer parties do not plead and may not know exactly what, if anything, the Lively parties and the New York Times communicated to each other. So pointing out that he's making these claims about what they've said, but also he doesn't actually know what they said. Accordingly, the amended complaint fails to allege facts regarding who said what, if anything, to the New York Times and when. The amended complaint instead relies on inferences from the fact that the Times had the CRD complaint before it was publicly available, and on conclusory and often dramatized allegations, sometimes on information and belief, that the Lively parties worked together to feed the Times a false narrative. Again, calling out that they're using this hyperbolic language and don't really have a ton of evidence to back their claims. Apparently based on text messages that were selectively and deceptively edited. This gets reused so often through his opinion. The Wayfarer parties had responded to Lively's complaints about purported sexual harassment by plotting to destroy her reputation via a smear campaign. A plaintiff who is unable to plead direct facts must, at a minimum, plead circumstantial facts supporting a plausible inference that the defendant's behavior crossed the line from lawful to unlawful conduct. So he's already accepting that, look, they don't have direct facts, so now there really should be like arguing these circumstantial facts to support their evidence. If the Wayfarer parties allege facts supporting that a given defendant made statements to the Times that were true, privileged, or mere opinion, coupled with a bare assertion that defamation occurred, the pleading is insufficient. On the other hand, if the Wayfarer parties pled facts, including circumstantial evidence that create a plausible inference that a defendant made statements to the Times that were false, defamatory, and unprivileged, the Wayfarer parties have stated a claim. The factual allegations pled in the amended complaint do not state a claim. So he's arguing here, like, this is the basis of what they needed, and they missed. They support at most a plausible inference that Lively or someone acting on her behalf provided the Times with a copy of the CRD complaint and related text messages before the complaint was filed. While the article was published on December 21st, the day after Lively filed her CRD complaint, the Times asked the Wayfarer parties to comment on the article at 9:46, reporting on the complaint on the same day it was filed. There is a powerful inference that the Times had access to the CRD complaint well before that date. The article and the CRD complaint are both purportedly based on thousands of text messages, which the article states were reviewed by the New York Times. URLs for images, PDFs, and videos contain the dates December 10th, 12th, and 16th. The article draws heavily from Lively's CRD complaint, and it would have taken time to review that complaint and its attachments. So he's accepting that, yes, I think your allegation that the New York Times worked on this article for a while, I think that's true, right? Because the Times had access to the CRD complaint before it was filed and while it was still confidential, there's also a powerful inference that it was provided by Lively or somebody on her team. Lively obviously had access to the CRD complaint before it was filed, and it only makes sense that the CRD complaint was given to the Times by Lively or someone acting on her behalf. So is that saying, yep, everything seems to check out with your story so far? It does say, though, the same inference does not hold as to Sloan or Reynolds, which provides an independent ground for dismissing the defamation claim based on these statements as to them. Lively is the plaintiff in the CRD complaint, and even if she did not personally provide it to the Times, it's plausible to infer that she authorized or made the decision to provide it. Sloan and Reynolds, however, are not plaintiffs in the CRD complaint. There's no reason to infer they would have approved or been responsible for the provision of the CRD complaint to the Times. So again, arguing this conspiracy that the three of them work together, saying there's nothing in here. The mere fact that they are related to Lively as her publicist and her husband does not provide a basis for an inference that they made or were responsible at any particular time statements to the Times. The act of providing the complaint to the Times is not sufficient to constitute defamation because the complaint is protected by fair report privilege. And this is why I say, like, he doesn't really dig into like the California code, because he's saying here, just based off the providing this to the Times, it's covered by fair reporting. We don't need to get into the 47.1, it's sexual harassment and protected. They argue that it was provided before she filed. He argues, nope, under California law, a party need not wait till a legal document is formally filed before providing it to the press. What's next? What are we at? 85. Oh, he goes on to argue that the litigation privilege can protect statements in a complaint that has not been filed if they're related to an imminent lawsuit or judicial pleading, which is actually contemplated and seriously and in good faith, which Wayfarer and Baldoni's team had argued it wasn't. She wasn't really seriously contemplating filing it. And he argued this in the lawsuit that he filed to the New York Times the same day that she filed her lawsuit against him, which was amazing. I love that part of the New York Times complaint where he's like, she's not even seriously going to take this to court, he says, filing his lawsuit on the same day that she takes him to court and proving as soon as they put that on the docket that they were wrong. Thus, if the CRD complaint had been sent between the Lively parties or to an adversary as an attempt to secure settlement in good faith before the complaint was filed, the statements would be regarded in the course of the proceeding and the litigation privilege would apply. There is no basis to infer anything other than the litigation was contemplated in good faith because, she filed the complaint within months of the events described in the complaint, and it was not long after it was plausibly given to the Times. 11 days after she filed the CRD complaint, Lively filed suit in this court, making the same allegations she made in the CRD. The Wayfarer parties assert the fact that Lively eschewed the administrative process and filed the suit in federal court instead demonstrates that she did not file her claim in good faith. You have probably heard this argument a bunch of times. She didn't get the CRD to investigate her claim. Liman goes on to say that doesn't need to happen either. The fact that Lively chose to file in federal court rather than continue in the administrative process does not deprive her of the benefit of the privilege, that she's allowed to just progress to court and not kind of spend time having the CRD investigate. Because it's common that plaintiffs with more serious discrimination claims would prefer to bypass the administrative procedures to seek a vindication of their civil rights. Essentially, if your case is strong enough and you want to go immediately to court, you don't need to do the investigation. But I'm sure you've heard this on social media a bunch of times. Oh, she didn't have the CRD investigation. She wasn't serious about it. She just went straight to court. And if anything, the fact she went to court shows how strong her case was. She did not need the investigation to then see whether she would be able to take this to court. I haven't waded through the whole document. Is Vituska brought up? He is. Vituska's brought up as we get a little later, but he's brought up in the sense of his statements are taken as they were before he corrected. So I think Liman's decision here comes before Vituska had given his declaration, and it doesn't take that into consideration, which is, I think, is correct, because again, this is the motion to dismiss. He has to assume what they're saying is the truth and do so based off those merits, not off the evidence we now know that essentially their complaint was full of crap. So he has to take it that it's true. Gina says, I have to leave for work in 5 minutes. I am so sorry, but I appreciate you hanging out with us. I hope you have a great day at work. Liman doesn't, Junk says, Liman doesn't want to be overturned in an appeals court telling you should have added X. He's saying, I thought of X, Y, and Z. Yeah, he is meticulous. Again, I'm incredibly impressed by this. I assume he must have a team, because if this is one person who sits here thinking about all of these cases and doing this, that is a ton of work, and I would never want to be a federal judge. My lady says, God, everything about that defamation lawsuit has aged so badly. Yeah, everything. How can you argue she wasn't going to sue after she already sued you? Says all scientists. Yeah, on the same day, arguing on the same day she sues you that she's not going to sue you. Just beautiful, just beautiful. All right. So the Wayfarer parties would have the court infer that the preparation of the complaint was merely an attempt to use the litigation privilege to shield her behind-the-scenes conspiracy with the New York Times. But as described below, there were no allegations of conspiracy other than that Lively provided the CRD complaint and the messages to the Times. The Wayfarer's argument is best understood to claim that Lively used the filing of the CRD complaint as a pretext to spread defamatory statements to the Times without incurring the potential liability that would arise if she provided those same comments to the Times in a form other than through a complaint. Again, we've heard this before, right? Like, oh, she was just doing CYA. She never really intended to file a lawsuit. She was just doing this so she could work with the Times and be protected. And then she filed a lawsuit that has dragged on for 6 months and it's got like another year. So not really an efficient way of being able to publish a New York Times article. The Wayfarer party have not alleged such facts. To the contrary, the amended complaint and facts of which the court can take notice show that Lively did pursue her legal claims. So, the amended complaint plausibly alleges that Lively provided the Times with texts and messages and emails that are not included in the complaint. He goes on to kind of pull this piece out and say, the Wayfarer parties do not allege that any of the text messages and emails not included in the CRD complaint were defamatory. The messages in the article and the video provide the strongest support for the smear campaign are those that are included in the CRD complaint, with those not lending minimal, if any, additional support to this narrative. So he's making the argument that Wayfarer are talking about, well, there was a ton of other messages they didn't that they looked at and didn't include, but you're not saying that any of those are defamatory. All of the defamatory ones are the ones that were included. On the contrary, the messages discussed in the article, but not the CRD complaint, are often supportive of his narrative. Again, New York Times brought this up, saying that, hey, we didn't add anything in that wasn't already in the CRD complaint, other than a lot of stuff from you. Everything, like, not everything. A good chunk of the article that isn't the CRD complaint is essentially bringing up her mistakes in promoting the movie, what Wayfarer are denying, and their messages and other things. So this idea that they, published their CRD complaint and then they had all of these other messages And then if those weren't in the CRD complaint, most of that didn't hit their article. In fact, the exhibit of the other text messages, I think there's like 7 or 8 text messages that just aren't included in the article. Sorry, that aren't included in the CRD. It just, there's not much into it. Chung Pham says this dumb judge just doesn't understand magic time traveling Uno reverse emojis. Oh, the Uno reverse emoji is in here. It's in here in a little bit. The amended complaint alleges the Times had access to a plethora of communications demonstrating that Lively's narrative was true. So their major complaint is they should have known this was not true because of all the other text messages they had, that said none of this happened. But if Lively had provided those messages to the Times reflecting that a smear campaign was not waged, that would not be defamation. So it's not defamation that she provided these text messages to them that don't show that. The Wayfarer parties additionally alleged that Lively provided the Times with text messages that were selectively and deceptively edited, but that does not add to her claim. The amended complaint alleges the selective and deceptive editing was simply the editing of the CRD complaint, i.e. that in the CRD complaint, Lively provided excerpts of messages that were deceptively edited, right? Talking about excluding the emoji. The Wayfarer parties assert, as litigants frequently will assert, that the version of events recited by their adversary is selective and does not tell the whole story. Essentially, the basis of their claim for defamation is not that anything was defamation, it was that she selectively took text messages to create a narrative that wasn't true because there were these other text messages that showed that's not the case, and that she's just presenting it in the best possible light. Every single person does that when they go to trial. You do not present a balanced lawsuit where you're like, on the one hand, I could be telling the truth, but on the other hand, I could be full of lies. Like, they do the same in their complaint. They paint everything in their best light. For example, the I'm pumping in my trailer text message. It's highly unlikely, right, that was an example of him being invited into her trailer, given that the messages right after it show that he did not go to her trailer. He was waiting somewhere else. And yet they have tried to use it in that way. So yeah, I mean, like, everybody who files a lawsuit is going to put the best possible case and interpret the facts in the best possible light. And Liman is doing exactly that in how he approaches the motion to dismiss by taking their complaint and painting it in the best possible light. That in itself is not that defamatory. Liman is not defaming Blake Lively by accepting Baldoni's view of events here. Sorry, I'm getting a little animated. But that the CRD complaint painted a deceptively favorable picture in favor of Lively and took quotations out of context does not deprive Lively of the litigation privilege. A litigant is not required to file a balanced pleading before an agency or in the court. She is permitted to marshal the facts to tell her side of a contested story, and an adversary cannot invoke the law of defamation and defeat the privilege by contending that the allegations are untrue. He must respond in kind by telling his side of the story, as Baldoni has done if the CRD complaint was privileged, as the court has held it was. The addition of the claim that it contains selectively edited emails does not do away with the privilege. The fact that she cherry-picked the best possible text messages and emails to prove her case does not make it defamation. Where are we at? I think we got that, and then... To the extent that the Wayfarer parties mean to assert that the Wayfarer parties separately sent the Times selectively edited messages beyond merely providing the Times with a CRD complaint that had selectively edited messages, no facts support that conclusory allegation. Again, they rarely talk about any text messages that are outside of the CRD. If Lively wanted to paint an overly rosy picture of her narrative and did so by selectively quoting messages in the CRD complaint, there is no reason why she would need to provide the Times with other selectively edited messages. No such other selective edited messages are pled. They don't provide any evidence of it. The amended complaint insinuates that in addition to leaking the CRD complaint and providing the Times with emails and messages, Lively, Reynolds, or Sloan parties could have made other specified communications presenting their version of events. They could. But the Wayfarer parties allege no facts to support those insinuations. Attica Silva, good to see you. Welcome in. Allegations that Lively and her co-conspirators told the Time a false and damning story about an insidious PR sabotage operation or that Lively spread a narrative the Wayfarer parties had responded to Lively's complaints about purported sexual harassment by plotting to destroy her reputation through a shadow smear campaign are indistinguishable from the allegations she leaked the CRD complaint. Essentially, it's duplicative. You're arguing that she defamed you by making statements that are the same as the ones that are in the CRD complaint. The alleged narrative peddled by Lively and her team is simply the narrative of the CRD complaint. But Wayfarer have tried to argue, well, she provided the CRD complaint, and then also they presented all of these other defamatory statements that are just them repeating the CRD complaints. It's, yeah, it's bad. All right. Then we get to the sexual assault and predator statement. We're running long, but we're almost there. We're almost there. Where we're at, page 90. So that is on here. Yeah, it's simply the repeating of the CRD complaint. The Wayfarer parties alleged, based on paragraph 270, that Lively told the Times the Wayfarer parties' agreement the 17-point letter was proof positive that sexual harassment was endemic on the set. However, this paragraph is not fairly read to allege that Lively made any such statement. The statement that the demands allowed her to later claim the Wayfarer parties' agreement to the demands proved their wrongdoing does not clarify when, where, or to whom, or if she ever actually claimed this, as opposed to simply stating that the demands allowed to do so. The paragraph does not put Lively on notice. So they say, I think, in their effect, that it allowed her to be able to say that doesn't show that when they did that. Where is it? Right there. When she buffaloed the Wayfarer parties into agreeing, she sealed the perfect narrative poison pill, allowing her to later claim that the Wayfarer parties' agreement to the 17-point letter was proof positive that sexual harassment was endemic on the film set. Doesn't prove that she did do that. You're just kind of using this word to do some heavy lifting, saying she could, but you don't actually say when, where, who, and how she actually made that statement. So there's no reason to take that as an actual defamatory claim because you cannot show that one actually happened. You're simply suggesting one might have occurred. And again, it kind of speaks to just how weak their case is that they have to kind of put in this language of she might have done this. Okay. So going on to sexual assault and sexual predator claims, this is where I talk about, saying that this is the Vituska email we talked about. Sloan told the Daily Mail reporter Vituska that Lively was sexually assaulted, and Reynolds told the WME and Baldoni's agent that Baldoni was a sexual predator. The Wayfarer parties have not alleged these statements were made with actual malice, and thus their claim fails. So this is what I talked about before. Basically, Liman argues that there's no reason to suspect that either Sloan or Reynolds did not believe these statements based on the arguments that were true. Now, Wayfarer assert that, Lively had spun a false narrative, but they haven't actually shown anything. The Wayfarer parties have not alleged that Sloan or Reynolds had knowledge that the statements they are alleged to have made were false, or that they entertained serious doubts as to their truth. Because Baldoni is a public figure, he may only recover if the statements were made with actual malice. Again, not that we don't like the guy, actual malice meaning they made the statements knowing them to be false. Oh, Liman actually calls that out right there. I should have just read the rest of the sentence. Meaning actual knowledge of falsehood or reckless disregard for the truth. That's it. Not just that they didn't like him. At the pleading stage, a plaintiff in federal court cannot simply state in a conclusory fashion that the defendant knew that a statement was false. He must plead facts demonstrating the claim of actual malice is plausible. Doesn't have to say that it's true, that he has complete proof of it, just that it is plausible. Liman says it is not plausible. The Wayfarer parties don't contest that Baldoni is a public figure. They argue that the other Wayfarer parties are not public figures. However, the sexual assault and sexual predator statements are statements about Baldoni, not the other Wayfarer parties. The other Wayfarer parties cannot recover for these statements under any standard. And I talked about this on Threads. That to me is a huge red flag. When we're talking about the fact that they have those Rule 11 sanctions up right now, where they're talking about no lawyer would have brought this claim for defamation for against Ryan Reynolds from like Jennifer Abel or Steve Sarowitz or the It Ends With Us movie. There's no way in which Reynolds saying that Baldoni is a sexual predator allows them to claim defamation, allows Jennifer Abel to claim defamation. Liman calling out here, the other Wayfarer parties cannot recover for these statements under any standard, is pointing out that there was never any world in which those Wayfarer parties could have brought a claim for defamation that would survive. And I think, like I say, that is a huge red flag if I'm reading that as Wayfarer's legal team of where those Rule 11 sanctions might go. I would be very, very nervous. Direct or circumstantial evidence must be pled, such as failure to investigate, anger and hostility towards the plaintiff, reliance upon sources known to be unreliable, or the plaintiff's possession of contrary information. Must have some reason to doubt that what they're saying is not true. The alleged complaint, the amended complaint alleges that after publication of the CRD complaint, Lively told a reporter that Sloan told a reporter that Lively was sexually assaulted. The amended complaint alleges this statement is false because all contact between Lively and Baldoni was consensual and within the bounds of their roles. The Wayfarer parties allege that Sloan made this defamatory statement on text messages sent by Nathan to a reporter for the Daily Mail after the CRD complaint was released that stated, amongst other things, she said the whole cast hates Justin. This has nothing to do with Blake, and now she's saying that Blake was sexually assaulted. Why wouldn't she say anything about that then? So these are the Vituska text messages. Sloan argues that these text messages do not in fact show that Sloan told the reporter that Baldoni had committed sexual assault. She argues the phrase was not a direct quotation and appears to be the reporter's characterization, blah, blah, blah. The messages may also be a paraphrase, and it's possible that Sloan used innocuous language the reporter characterized as a report of sexual assault. And then basically the reporter's statement that Sloan is saying that Blake was sexually assaulted supports a plausible inference that Sloan told the reporter Blake was sexually assaulted. So, like I said, he's not currently taking into account what Vituska has now turned around and said. He's saying, actually, like, there is a reading of those text messages that supports Wayfarer's claim here, right? So he's actually deliberately calling out that I am taking the Vituska emails as Wayfarer have said they are, not as we've now learned they were, and actually trying to read everything in the best possible light. And even in that context, it still fails. I swear in an affidavit that somebody told me something, that kind of hedging. Yeah, he does that a lot. Speaking of, we haven't heard anything more about that. The whole I heard somebody tell me this, and now I've got the text messages, and now we have evidence of crime, has not hit the docket. I have seen a couple of people make that claim that now that the Justin Baldoni's civil case has been dismissed, that opens the way for a criminal case, that they somehow needed the court to toss away a civil case before they could pursue a criminal case, which I'm not familiar with the law that says you can't have two cases in two courts, but apparently that's one of the ways in which we are responding to their case being completely thrown out. All right, the amended complaint alleges this statement is false because all contact between Lively and Baldoni was consensual within bounds of their roles. We read that. However, the amended complaint does not allege facts to support the inference that Sloan would have known that the sexual assault statement was false. Sloan was Lively's PR agent. She was not Lively's custodian. There was no allegation that she was present when any of the contact between Lively and Baldoni occurred, nor are there allegations that she would have been told secondhand by Lively or Reynolds anything other than what Lively alleged in the CRD complaint. From the facts available to Sloan, the contact between Lively and Baldoni was not consensual, nor was it within the bounds of their roles. As the amended complaint alleges, Lively's version of events included that there was inappropriate and improvised kissing. The CRD complaint, which was filed prior to Sloan's statement, more specifically states that without Lively's consent, Baldoni discreetly bit and sucked on Miss Lively's lower lip during a scene in which he improvised numerous kisses and dragged his lips from her ear down her neck, caressing Lively with his mouth in a way that had nothing to do with their roles and makes me nauseous. The CRD complaint referenced Lively's earlier return to production demands, which lent credibility to Lively's claims of sexual harassment. Sloan is not alleged to have reason to believe that Lively was untruthful. The statements were contained in a legal filing on behalf of and by a person whose credibility the Wayfarer parties do not allege Sloan had reason to doubt. In the absence of allegations suggesting Lively's account was inaccurate or that Sloan would have reason to believe Lively was being duplicitous, Sloan had no duty to investigate. So she was just believing what she was told and did so in good faith. Moreover, once Sloan credited Lively's account of the facts, she could also have reasonably and not recklessly concluded that Baldoni had engaged in sexual assault, basically going that yes, it fits with that dissent. You know, this is again what Sloan had argued in her motion to dismiss, that the bite on the lip and caress of the neck with the mouth without consent would fit within the definition of sexual assault, not merely just sexual harassment. The Wayfarer parties argue that as a close associate, Sloan had a motive to defame Baldoni. Aside from the generic premise that Sloan was Lively's publicist and was on her side of the conflict, no allegations suggest any particular benefit Sloan would have derived from telling a falsehood in this context. Let's see, what else? It's true that the CRD complaint doesn't use the word sexual assault or accuse Baldoni of sexual assault. It frames it as sexual harassment. But the issue is not whether Lively characterized her experience as sexual assaults, whether Sloan would have entertained serious doubts that Lively was sexually assaulted based on the information imparted to her. The Wayfarer parties have not alleged facts establishing that Sloan was reckless in characterizing non-consensual kissing, biting, and touching by Baldoni of his mouth to Lively's neck to be sexual assault. And again, I think this is, again, damaging for what is to come in the future cases, because, again, this is stuff that his publicist was okay with being out there in those news stories, that they were editing out the other stuff because they were like, oh, we're comfortable about the kissing and the touching, and that, oh, Lively was just being too much of a prude type thing. Liman is making the point that that would reasonably consider to be sexual assault. That's really bad when you are got a pending case for sexual harassment. But we'll see how things go. More importantly, a person bears ill will or malice in the ordinary sense of the term towards another does not establish that the person has actual malice with respect to their statements in the constitutional sense. Liman here directly calling out a lot of, like I say, this commentary where, oh, well, you know, they wanted to harm Baldoni, so they had actual malice. That they wanted to harm him or that they didn't like him is not the actual malice standard that is being used here. Actual malice meaning that they had reason to doubt what they were saying was true, that they were intentionally saying something false, essentially, or that they knew could be false. The amended complaint repeatedly alleges that Sloan was part of a conspiracy to spread knowing falsehoods. However, these allegations are entirely conclusory. Sloan was Lively's publicist, and she presumably worked with Lively, but there's no factual allegations to support that Lively told Sloan she was not sexually assaulted, or that Lively and Sloan agreed that Sloan would spread rumors of sexual assault, despite knowing that they were false. Even assuming Sloan accused Baldoni of sexual assault, the Wayfarer parties have failed to support an inference that she was not simply reporting what she was told by Lively and genuinely believed. This was a huge part of Ryan Reynolds' motion to dismiss, was that, no, I genuinely believe this man is a sexual predator. I genuinely, deep in my heart, with everything that I hold, believe this man is a predator. That is why it's not defamation. Liman here basically upholding that idea of, yeah, no, they both believe that this dude is a bad dude. Now, again, make it clear, Liman is not saying that it happened. He's not supporting Lively's versions of events. He's simply saying that from the perspective of Sloan and Reynolds, that without any evidence of being told that these things were false, they had every reason to believe that the return to production, the CRD complaint, upheld that Lively had been sexually harassed. And again, I think that's a big thing to not gloss over, because as we kind of push forward with this, Friedman is still talking about how all of these sexual harassment allegations are false. But, you know, her complaining on set multiple times, having multiple meetings on set, having the protections for return to production, having the meeting on return to production to go over the list, all kind of reinforce that this is a legitimate concern where she was uncomfortable, as well as complaining to Sony and Sony complaining to Wayfarer. This idea that she just invented sexual harassment claims doesn't seem to be based on anything, and they haven't shown any evidence of them making them up. In fact, all of the incidents that she said occurred did actually occur. They just differ on how they interpreted them and what the intent for those were. Obi-Wan Kenobi says truth is an absolute defense, and if the creepy predator suit fits, yeah. Junkfam says this part, how the hell do you make a $25 million picture about DV without a signed consent form? What form it is? Oh, I mean, like I could talk for this for days about like that, and I think I've talked about like there should have been an intimacy coordinator on set permanently, not just for specific scenes. I think there should have been a therapist on set permanently as well, especially when dealing with it. And I think there should have also been a domestic violence consultant for people to talk to about the scenes and also about like maybe their own personal experiences, because I think it would be very triggering. Again, I think that's why there should be a therapist on set. I think, unfortunately, Wayfarer are just like super cheap and tried to cut as many corners, make this as cheaply as possible. And I think that kind of spells out with a lot of how, if you look in the complaint, they're upset over having to hire an additional producer. They're upset at having to pay for 2 premiere parties. They're upset at all of the things that change or cost money get called out in their complaint. And that could just be because they're strengthening the case for damages. But I also think there is genuinely a grievance that things like Lively not crossing picket lines when they were picketing and increasing production costs really just burn them up. All right, so Reynolds, I mean, basically the same thing. I don't necessarily feel like I need to go through this. I did like, where is it, this piece here? You know, in fact, several allegations in the complaint support that Reynolds does believe that Baldoni engaged in sexual misconduct towards Lively. During pre-production, Reynolds screamed at Baldoni after finding out that Baldoni had asked his trainer about Lively's weight. Reynolds then later yelled at Baldoni and demanded he apologize for actions that never happened in connection with the return to production demands, becoming further enraged when Baldoni refused to apologize. Given that the return to production demands concern Baldoni's alleged inappropriate behavior towards Lively, the obvious inference is that Reynolds was yelling about Baldoni about this alleged behavior. And although Baldoni denies the behavior, mere denials, however vehement, are so commonplace in the world of polemic charge and countercharge that in themselves they hardly alert the listener to the likelihood of error. Basically saying that, sure, Baldoni denies this, but it is so commonplace for people, he's saying people, but let's be real, so common for abusers to deny their behavior and not accept that they made people feel uncomfortable. That in itself would not give Reynolds or anybody else pause to think, oh, what I'm saying about you is untrue, right? If I call you a predator, you saying, I'm not a predator, would be just a normal defense that somebody would say because they don't want to be called a predator, not because they're like, no, actually you have it wrong. And it wouldn't cause a normal person to say, oh, they denied being a predator? Oh, I maybe have got this wrong. So that's why he's bringing this up. He's not necessarily calling out Baldoni and saying he doesn't believe him, but I thought that was an interesting point to make in there, saying that like just because he denies it doesn't mean that you have to believe his denial, especially since that is essentially Baldoni's entire case, is that he denies it and the people who are still defending him believe him just on the basis that he denies it. These facts tend to suggest that Reynolds believed Baldoni had inappropriately commented on Lively's body and then engaged in appropriate or predatory actions towards Lively during filming. The parties argue that actual malice can be inferred from Reynolds' deep disdain for Baldoni and that he was trying to convince WME to drop Baldoni, but as we noted above, that's not what actual malice is. And to get a kind of like legal dressing down from a judge like this of like, you don't understand what actual, like pleading actual malice means, is pretty embarrassing, right? As much as we have all the rest of the stuff, that's pretty bad. It's fine for us to not know that. We're not legally trained. It's fine for people on TikTok to not know this or Twitter. But for a judge to point out to a lawyer that like you misunderstood malice, like you misunderstood the actual malice to just mean malice. That's not what we're talking about. Reynolds may have disliked Baldoni, but that does not mean that he knew that Baldoni had not engaged in misconduct or was reckless with respect of whether he engaged in that conduct. No actual malice exists when a defendant seeks to harm a plaintiff by spreading facts the defendant genuinely and not recklessly believes that are true. Reynolds argues that sexual predator statements are substantially true, and then he says, well, you know, the argument relied on evidence that may not be properly considered in a motion to dismiss, talking about his book and statements and all the rest of the stuff. If Reynolds seeks to introduce that outside evidence, he said Baldoni must be allowed to introduce his own evidence rebutting that charge. So just a point, because Reynolds kind of said that this was based on all of his podcasts and books and stuff, and Liman calling out that I'm not really going to bring that in and talk about that. The Wayfarer party's theory of case is that Reynolds, Lively, and Sloan all knew that Baldoni's behavior was appropriate, but conspired to exaggerate and fabricate events that had not occurred on set. The amended complaint alleges that Lively knew there was no sexual misconduct, and the Wayfarer party's desired inference is that given Lively's close relationship with Reynolds and Sloan, she would have told them the truth. But the court cannot simply infer on the theory that Lively knew her allegations were false, that Reynolds and Sloan would also have known them to be false. And so, therefore, the Wayfarer parties must plead more than factual allegations that Sloan and Reynolds made false statements, combined with a bare assertion they knew they were false. And that is why they fail. They talk about the additional statements by Sloan to the Daily Mail reporter, talking about Lively's accumulation of power, the resulting turmoil, talking about the problems on set involving Lively and Baldoni. That your info's totally off, you have it all wrong, your reporters are wrong, the cast doesn't like Justin, it's nothing to do with Blake. He talks about these statements are opinion, they're not actual fact. In the context of Sloan's hyperbolic defense of Lively, the statements cannot be taken as literal assertions that every single cast member hated Baldoni for reasons entirely unrelated to his co-star in the film. Rather, they convey a general view that Baldoni is disliked and the cause of any problems, an assertion which contains too many elastic terms and elements of subjectivity to be subject to proof or disproof. So, arguing that it was opinion. The Wayfarer parties argue the statements imply undisclosed fact because they would imply that Baldoni had engaged in misconduct or otherwise. But Liman goes on to say, it may be reasons for that. It may be reasons because, he's demanding, obstinate, incompetent, or simply annoying. It may be for no particular reason. People might just not like him for their own reasons. It may reflect poorly on the cast and not on the director. Maybe the cast are just difficult to work with and jerks. By saying that they disliked him, it doesn't necessarily mean that he had to have done something to get that reaction. But I think that does kind of speak to, again, where they're going with this, because there's no inference in that the cast doesn't like Justin. It could just be the cast doesn't like Justin because Justin made them work too long. It could be the cast doesn't like Justin because Justin is disorganized. They're used to working on a different kind of set. He doesn't work the same way they are. The fact that Wayfarer take the cast doesn't like Justin to mean Justin did something, I think is them kind of tipping their hand that it really was because Baldoni did something, at least in my understanding of it. Obi-Wan Kenobi says, crazy how Ryan and other men in the cast listened to a woman and believed her. Yeah. Ah, gosh, that would be embarrassing. You stand up and do a whole TED talk about that and then not follow through. I'll say this is my favorite paragraph. Liman made choices in describing why people didn't like him. Yeah. I mean, he took his time to describe certain things. I don't think he actually is describing him, but if you want to take that and use that as a list of adjectives for him, you descriptors, you can go for it. How do I hate him? Let me count the ways. And another thing. All right. Lively is responsible for the statements by Reynolds and Sloan. I talked about this. I don't necessarily want to go into it. Again, he talks here about the Wayfarer parties allege that the cast hating Baldoni had nothing to do with Lively can be disproved by showing that, as in the alleged complaint, Lively induced the other cast members to shun him. But that, he says this argument confuses the issue. The issue is whether Sloan made a factual statement about Baldoni, not whether she made a false factual statement about Lively. That it was nothing to do with Lively is best understood as a statement that the problems with the cast were predominantly Baldoni's fault, not a statement that Lively literally had nothing to do with it. So they're trying to flip it around. This is the respondat superior that we talked about, which he again makes the point of it's based on the fault of the employee, not the employer, though they're trying to flip it around. Sloan has done no wrong for which Lively can be vicariously liable by saying, look, there's nothing there in terms of defamation, therefore this whole thing can't trigger because there's nothing she's done. This theory does not require Sloan herself to have known the statements are false. Instead, it requires that Lively to have known the statements were false and to be responsible for Sloan making them. A person who directs the conduct of another may be subject to the tort liability because of an actor's conduct, though the actor is not subject to liability. So basically, if she didn't correct her statements. If Lively approved Sloan or Reynolds' sexual assault and sexual predator statements and authorized them to be made, she could be held liable for those statements even if Reynolds and Sloan were not liable. However, the Wayfarer parties have not plausibly alleged that Lively is responsible for them. There's no allegations supporting that Lively agreed in communicating with Baldoni's agents. Makes the point that Reynolds himself is a client of the agency and could be representing and communicating with the agency on his own behalf. What proof do they have that he was there as a representative of Lively, not simply representing his own relationship with WME? The Wayfarer parties have not plausibly alleged that Lively is responsible for Sloan's sexual assault statement. The non-conclusive allegation in the amended complaint is that Sloan is Lively's publicist. They talk about there's no allegation that Lively was aware of Sloan's statement before she made it, and even if assuming Lively authorized Sloan to communicate with reporters generally, that fact is not sufficient to support an inference that Lively authorized Sloan to make a defamatory statement that, she'd been sexually assaulted. The fact that Sloan is Lively's publicist without more suggests that Lively controls the direction of Sloan's communication generally, but is not sufficient to support that Lively controls Sloan's word choice in each text message, which again speaks to a lot of the narrative about this, that Blake Lively is this, this evil figure who's controlling everybody, this puppet master who does everything that they say, and Liman here calling out that, like, this is nonsense. There's no reason to believe that people don't have their own autonomy, and that as her publicist, that she is directing every single word that that publicist says. That is not the relationship. You haven't offered anything to show that that relationship, or in particular this particular communication, went beyond that regular and normal assumed relationship. The Wayfarer parties allege that each of the Lively parties conspired with the others to commit defamation, but they haven't. They can't win on that because they haven't alleged the underlying tort of defamation. So therefore, they can't be liable for a conspiracy theory if there's no underlying tort. The amended complaint shows at most only that Lively made a communication of the CRD complaint to the Times, which was privileged, and that Reynolds and Sloan made statements regarding Baldoni's sexual harassment that they believed they were true. The Wayfarer parties' conclusory allegations that Lively, Reynolds, and Sloan engaged in conspiracy to defame the Wayfarer parties by disseminating knowingly false statements cannot substitute for factual allegations supporting a plausible inference that this occurred. Basically, you don't just get to make stuff up, you actually have to provide substance. Open Welcome Hobby on the voice notes. Oh, the voice notes were so creepy. So creepy. All right. 106. So we go into the New York Times. Essentially, the New York Times is privileged. They didn't really respond to anything else. I don't think there's anything else in here. 109. Yeah, I mean, they talk about, look, they stated these general things. The Wayfarer parties, the Times falsely stated the Wayfarer parties orchestrated a retaliatory public relations campaign against Lively for speaking out. This and similar statements are not sufficient to put the Times on notice that the Wayfarer party's defamation claim was based on any statements that sexual harassment occurred, as opposed to that the Wayfarer parties orchestrated a smear campaign. Kind of calling out that they seem to be smushing the two together. But yeah, I don't think it was that. The only other piece that I really wanted to kind of get into on this, 113, I think. Where are we? However, so what we're talking about, the Wayfarer parties failed to allege the Times made the statement with actual malice. Again, the Wayfarer parties concede that under New York law, the actual malice requirements extends to claims brought against all the Wayfarer parties, including not only Baldoni, but all of them. But they say that The actual malice is satisfied because they reviewed internal communications directly refuting the article. But in response, the Time argues the text messages contained in the article and CRD complaint, the authenticity of which has not been disputed by the Wayfarer parties, show that the Wayfarer parties did in fact engage in a smear campaign. Therefore, the issue here is whether documentary evidence of undisputed authenticity would plausibly indicate the Times made the statement that the Wayfarer parties engaged in a smear campaign against Lively with a high degree of awareness of the statement's probable falsity. Even drawing all reasonable inferences in favor of the Wayfarer parties, the evidence does not support that the Times would have held such doubts, arguing that, look, there's a bunch of information that they looked at that supported their claim. The CRD complaint in the article contained numerous messages and documents strongly suggesting the Wayfarer parties did spread negative stories about Lively. Again, Wayfarer accept these messages. Specifically, Abel stated to Nathan that Baldoni feels like she wants to be buried, that Nathan responded, "We can't send over the work we will or could do because that could get us into a lot of trouble." The scenario planning document, talking negative statements about Lively's key messaging points. Subsequently, Abel texted Nathan that we need to put the social combat plan into motion, and Nathan to Abel about wanting to pound pieces of how horrible Blake is to work with by saying she already spoke to the editor at the Daily Mail. They talk about flipping the narrative on Reynolds, using their words against him, circulating a negative TikTok saying that it would let Digital know, talking about a shift on social due to Jed and these efforts, and so on and so forth. The Wayfarer party statements regarding sending negative content to Digital and Wallace's attempts to shine a spotlight on Blake and Ryan are inexplicable unless the Wayfarer parties were indeed spreading negative content about Lively, and this impression is reinforced by the messages from Baldoni, Abel, Nathan suggesting this strategy. It is fair to presume that the Wayfarer parties did exactly what they said they planned to do. So he's saying, look, there might be other messages that, say you didn't do this, but there's a ton of messages that look real bad that say you did, and that you have accepted as truthful. And so the way the New York Times would have made their claims about engaging in a smear campaign based off what they believed was probably true. The messages are what contained in the article and the video, referenced in the video. A reader of those messages would have little doubt that the Wayfarer parties did engage in a smear campaign. They go on to say that, look, they also talk about these other messages saying that not from any of us, and, that we weren't planning on doing this and all the rest of the stuff. The messages relied on the Wayfarer parties must be read together with the other messages the Times possessed. General statements to the fact that they're doing this themselves and we are doing F-all do not explain how a specific reference to Jed and his team's efforts to shift the narrative towards shining a spotlight on Blake and Ryan would be anything other than a reference to negative publicity about Lively, saying it doesn't matter that you have other text messages saying you didn't do it. There's enough in the text messages that say you did do it that any reasonable person would assume. And I talked about, at the beginning, why that's going to be important. Liman is basically saying here, a plain reading of your text messages would not give the New York Times doubt that you've engaged in a smear campaign. That's problematic as we come into, with this case dismissed, Lively's case, because he's basically saying that they have compelling evidence that you did do this. Now, Wayfarer are going to have to argue context and what they really mean and all the rest of it, and it's going to take a lot of explaining, unfortunately, to basically say, well, what we meant by Jed and his team's efforts, what we meant by shifting the narrative, what we meant by shining a spotlight. Liman's basically communicating ahead of time that this looks bad. And if the New York Times had those text messages in their possession, it is entirely reasonable that they would conclude that you engaged in a smear campaign. I think that's really not great look for them. He also goes on to point out this piece here in the footnote. Some messages relied on by the Wayfarer parties for the claim that they were not engaging in negative messaging regarding Lively and Reynolds can in fact be read to imply the opposite. A message from Baldoni to Nathan about protecting myself asks, so do we say that Blake and Ryan hired the Harvey Weinstein publicist? To which Nathan responds, that's a conversation I'm going to have with Jen and Jamie today. This implies that Baldoni and Nathan at least considered spreading a negative story regarding Lively's choice of Sloan as her publicist. In addition, the Wayfarer parties emphasized the text between tag members stating, we didn't tell Jed to go after the idea that her promo was inappropriate. That happened organically. But these texts can be read to imply that Tag did tell Wallace to go after Lively on other issues. If Wallace never spread anything negative about Lively, it is unclear why the Tag members would feel the need to note that Wallace did not spread this particular piece of negative publicity about Lively, which is also the same argument for I think there's like 2 messages of, we're not doing this, right? The one about Perez Hilton and then another one of something else. And again, the same argument that Liman's making here is the fact that they're saying, oh, this isn't us, right, implies that there's some confusion because they're doing other pieces that are similar, and they need to make that distinction between, is this us or is this not us? All of those text messages, by the way, are all after August 8th when they enact the digital combat plan. There is none of them before then. The confusion only happens after they've hired Jed. And again, like I say, the same thing that Liman's talking about here, by implying that, hey, we didn't do this right, implies that they are doing other stuff. Otherwise, they wouldn't need to make that clarification. You would know that all of the content was never you. Again, don't think that's great for Wayfarer to read as we're heading into their case, because Liman's basically saying, I feel pretty convinced that you're doing this stuff. I don't know why it's in here. I don't feel it's necessary as part of the motion to dismiss. He doesn't seem to be kind of equivocating and providing Lively's arguments in other places. I don't know if he really is just trying to signal to them how strong her case is, or whether he just felt to clarify that, like, hey, you can also read your text messages a different way. I don't know. Don't know. We packed it full of gas, but we never actually licked the match, says the junk file. I mean, that's been their argument since day one, right? We did hire a crisis PR. We did plan to go after her. We just didn't do it. That was Jen Abel's message on Facebook. Yeah, we planned all of this, but we didn't need to. It all happened organically. That has been their line since December 21st, that they just planned to do this and go after her. They just never actually followed through. How much longer we got? Okay, we only got 2 more pages. Okay. I will try not to keep you much longer, guys. I appreciate you sticking out through this. This was a long one. Liman, you guys should probably settle. Yeah, I think that's what he's saying. And I think we talked before about like Jen Abel needing new legal representation. This was, you should have done it months ago. Today is the second best time to go get new legal representation, because yeah, it's not going to go well. Get somebody else tomorrow. Yes, get the best you can afford, because sticking with Wayfarer is going to be so bad. They talk about the New York Times again. The article largely follows the narrative of the CRD complaint. It does include additional context favoring Baldoni. It acknowledges criticism of Lively's promotional efforts and comments that it is impossible to know how much of the negative publicity was caused by the smear campaign, indicating that she has other negative publicity just about her. It includes the Wayfarer denials. It states that Baldoni was unsure about the publicity tactics, and the Wayfarer parties believe that Lively was using the same tactics against them. These facts further cut against an inference of actual malice, right? They're trying to present some part of balanced in their reporting and offering the other side, and they're not just being all one-sided. The Times may have otherwise parroted the breathless smear campaign of narrative's complaint, but it had evidence to support that narrative, unlike Baldoni, I guess. It's not defamatory for the Times to dramatize the impact of the smear campaign or downplay Wayfarer party's side of the story, as long as the Times actually believed a smear campaign occurred. He goes on to say, there is actually only one specific quotation that the article could have taken out of context. The article implies that Nathan contributed to a Daily Mail article replying that is Blake Lively set to be cancelled. This is the one where, they say, you really outdid yourself, and Nathan replying, that's why you hired me, I'm the best. The complaint alleges that in the full context of the email exchange, the exchange was sarcastic, and Nathan did not contribute to the Daily Mail article. But an inference of actual malice may arise from allegations reported knowingly or recklessly misstates evidence to make it seem more convincing or condemnatory than it is. The amended complaint does not allege that this quotation in isolation is defamatory, nor is such a theory mentioned in the Wayfarer's party's briefing. They kind of argue that the thing as a whole is, and so that's why it fails. I think it's interesting that there's these little mistakes in here where he's calling out that if they had changed it slightly and gone for it, they might have had a better case. Even assuming that the Wayfarer parties prepared and laid the groundwork for a negative publicity campaign, but never in fact put that campaign into operation, and references to using their own words against them and shining a spotlight on Blake and Ryan were innocuous, it is not plausible that the Times would have known this, right? So they're saying that, look, even if you have innocent answers for all of this, it is not plausible they would have known this. And when you were asked for comment as well, you didn't actually provide any. False light, they don't really kind of go through much, but basically he just argues, much as what the motions to dismiss themselves argued, that the false light is duplicative. And he talks about the factual allegations simply allege in different words the same conduct that's alleged in constituting defamation. The court has already explained why the Wayfarer parties do not state a claim for defamation based on these allegations, to the extent that the Wayfarer parties mean to allege that Lively provided selectively and deceptively edited text messages to the Times through the CRD complaint. Such communication was privileged. To the extent the Wayfarer parties mean to allege that she separately provided selectively edited text, the amended complaint is conclusory. Wayfarer parties cannot benefit by the expedient of simply relabeling their defamation claims as false light. So, basically saying it's the same thing, they're making the same claims, so false light gets denied for the same reason. False light claims against the New York Times based on the same facts as the defamation claim, and so also it must be dismissed for the reason that it's analyzed under the New York law, and New York doesn't recognize false light invasion of privacy. All right. Junk Farm says, the one that kills me is when they shop the flower video to TMZ and tell TMZ it's totally organic. It's not organic when you're paying people to show it to TMZ. Yeah. Breach of implied covenant of faith. This is the only one. This is one of the ones that they will actually kind of redo. The Wayfarer parties allege that Lively breached implied covenant of good faith and fair dealing by making threats, seizing control, and depriving the Wayfarer parties of the opportunity to produce, edit, and market a film as contemplated by the contract. He argues, where is it? To state a claim for breach of implied covenant of faith and fair dealing, plaintiff must allege the existence of some sort of contractual obligation and interference with the plaintiff's performance of the contract. Wayfarer's breach of implied covenant allegations are conclusory. The Wayfarer party do not plead the terms of a relevant contract. So that's what he's basically saying, that this is why it's allowed to be repled. Wayfarer parties do not allege any particular contractual provision that gave them any particular opportunity to produce, edit, or market the film, or that prohibited Lively from her involvement in it. I don't think where he says it in here. I could have saw the Wayfarer parties attempt to specify the relevant contractual positions in their opposition, but the complaint cannot be amended by the briefs in opposition to a motion to dismiss. So they tried to include it, but he's basically saying you should have included it in your original complaint rather than trying to add it into your motions to dismiss, or your opposition to your motions to dismiss. I thought there was a piece in here where he says we need the contract. It might be, I guess, in the second piece. I'm trying to remember. So this is the interference with Ryan Reynolds, where we're making the claim to drop Baldoni, calling him a predator and all the rest of it. I think this is it. Under California law, they have to show the existence of a valid contract, the defendant's knowledge of that contract, their intentional acts designed to induce a breach of that contract, actual breach, and then resulting damage. So there's a lot of pieces to this. To do the prospective economic advantage as well, there needs to be an economic relationship between the plaintiff and some third party. The defendant must know of that relationship. There must be intentional act to disrupt that relationship. That relationship must then get disrupted, and then there must be economic harm caused by the actions of the defendant. Basically, he says that, where are we? The Wayfarer parties do not allege they had a contract with WME, the breach of which Reynolds knowingly induced, or any economic benefit that would have been realized from a prospective relationship with WME with which he interfered. They also failed to allege that WME was influenced by his statements in any way, aside from conclusory statements that WME ceased performance and then the relationship was disrupted, or the Wayfarer parties were harmed. And also, like, it was months after as well, which is going to hurt their claim. This is fatal to all three claims because there's no claim in the absence of facts showing that the relevant economic relationship existed and was disrupted. Also, the Reynolds statements, they don't allege that the Reynolds statements were defamatory, so there's no wrongful act. Finally, the Wayfarer parties do not admit to a care of duty to support the negligence claim, so they don't argue that, you know, Reynolds had a duty of care to not interfere with that and to protect it, so that also doesn't work. The promissory fraud, I'm not really going to go into because, I mean, like, he just basically calls it out. The claims are meritless, right? This is the whole, you can provide comment by noon, and then they published early, and then they tried to argue that it is. Liman just rips it up completely. He says they've not pled an existence of a contract. The emails don't constitute a contract. There's no offer, no acceptance, no consideration. The email sets a deadline of noon Eastern for comment, but it does not hold the offer to hold the publication in exchange for anything. The Wayfarer party's email does not accept any offer by the Times, or does it indicate any furthering comments are forthcoming. There was no breach, right? They asked for comment, a comment was provided, the Times considered it, included in the article, done. Promissory fraud also fails for the same reason. At most, the email says that the Wayfarer parties will have noon to send comments, that if the Wayfarer parties have not submitted comments by noon, the Times will publish. But the Wayfarer parties did provide comment. The comment was included in the article, and they did not suggest that further comment was coming. The Times did not promise to withhold publication after receiving comments, and no facts are pled to support that the Wayfarer parties relied on the alleged representation they had until noon to submit comments, or were injured by the belief they had until noon, rather than 10 a.m. to provide comment, which they'd already done. So it gets tossed out. I mean, like, we knew that whole thing was just so wild that they were arguing that an offer to comment by noon was, you know, a contract that they wouldn't publish by noon. Craziness. All right. So he goes on to say then basically, look, this is where it gets really embarrassing. He says the Wayfarer parties have sought leave to amend their complaint to cure any defects. Cool. Those defects being the Wayfarer parties' proposed amendments would, take a breath, here we go. 1. Cure impermissible group pleading. 2. Include additional facts relevant to choice of law. 3. Address the fair reporting privilege and actual malice as applicable to the New York Times. 4. More fully incorporate the allegations in Exhibit A, where the timeline of events that they said, oh, well, if you allow us to amend, we can pull that back in. 5. Amend the allegations relevant to the civil extortion complaint. 6. Amend the false light claim. 7. Add additional allegations of conspiracy to defame. Specify that Lively's contract requires her right to consult and approve of the film be exercised in a reasonable manner and not frustrate Wayfarer's production and development rights. 9. Adequately allege Baldoni's contract with WME in support of the tortious interference with contract claim. Defendants oppose leave to amend on the grounds of futility and undue delay. The court will not grant leave to amend the majority of Wayfarer parties' claims because amendment would be futile. The dismissal of the claims does not rest on technical pleading defects, and the Wayfarer have not made a showing that complaints defects can be cured. The Wayfarer parties do not identify any particular factual allegations that could be added to support the defamation or civil extortion claims, nor is it plausible the allegations not yet mentioned would change the basic substance of Lively's threats, the conclusion that the CRD complaint was privileged, or the conclusion that the relevant statements were made without actual malice. In addition to the 224-page amended complaint, the Wayfarer party has already submitted to this court an additional 168-page exhibit with additional details to their claims. Although the exhibit is not properly considered for the purposes of this motion to dismiss, the allegations within it would still not allow the Wayfarer parties to state a claim. In other words, not only did you file a 200-page complaint, you put another 160 pages of exhibits together, and even if I was super generous and considered that as well, you still wouldn't have a single complaint that you could, a single claim to make. This is bad. Like, this is a really bad dressing down from Liman. He goes on to say the exhibit contains additional details on Lively's threat, but if anything, these details cut against a finding of extortion. For example, The exhibit details that for some time Sony and Wayfarer in fact resisted Lively's requests, stating this is a Wayfarer movie. Wayfarer's final cut and runs the process. It then states that Lively did not sign her acting agreement so that she could continue to leverage her promotional participation as a bargaining tool. This is the piece that I was remembering about the employment contract. Implying that Lively may not have had a contractual obligation towards Wayfarer to promote the film. So it undercuts their extortion claim because he's saying that actually it does seem to suggest she didn't have a contractual obligation. Incorporating these facts would not aid the Wayfarer parties in alleging that Lively's threats were legally wrongful and could not be resisted. In fact, Lively did not owe the Wayfarer parties an obligation to promote the film. Her demands regarding what she would need in order to comply with their request that she engage in promotion would not have been wrongful. They would have constituted hard bargaining, saying it wouldn't have even, if we brought all that in, you still wouldn't have a claim for extortion. This is just her negotiating. Like, yeah, you may not like it. Yeah, she might have been demanding and asking for a lot, but that's all it was. Similarly, although Exhibit A contains a number of messages between Wayfarer parties not included in the amended complaint, these messages are consistent with those in the amended complaint and would not show that the New York Times acted with actual malice. Given that the Wayfarer parties have already provided an extensive record of facts that purportedly portrays their claims in the best possible light, the promise that more unspecified facts will now change central aspects of their core claims suggests dilatory. All right, help me out with this one, chat. Dilatory. They're trying to slow things down. I know what the word means, but goodness, some of these words you don't actually say them in normal speech. But anyway, it wouldn't change the central aspects of their core claims, and they're just trying to delay to extend the litigation rather than a legitimate belief that amendment will alter the court's determination. This is also pretty damning. Liman's basically saying, look, with all of this idea that you have a bunch of other evidence to bring in isn't going to change things, because what you've got here is going to be your best evidence. This is the best case you've got. You've had months to prepare this. You did your amended complaint. You put together 160 pages. The idea that you didn't put your strongest evidence in that and you just threw stuff in and we found more evidence behind the couch, right? Like we dug in the couch cushions and found more evidence is nonsense. And he's saying this is very clearly just a move to delay and to continue to drag it out, and I'm done. However, the court will grant leave to amend the claims for tortious interference with contract and breach of implied contract. So this is the part that I was saying, like, this is where I understood this to mean, okay, all of the tortious interference, so all four, right? He actually calls out here, the court will not grant leave to amend the claims for false light, breach of implied covenant, intentional or negligent interference with prospective economic relations, which is 6 and 7. Negligent and intentional interference with prospective economic advantage is causes 6 and 7. He actually calls it out here and says, no, you're not getting those. So I was wrong originally. Friedman is also wrong that he does not have 4 claims he can revive. He only has 2. Promissory fraud is also dead. False light claim is dead because it's duplicative of the defamation claim. Therefore, amendment is futile for the same reasons. The failure of the defamation claim against Reynolds is also fatal to the claims for intentional and negligent interference with prospective economic relations, which require interference be through a wrongful act. The breach of implied covenant and promissory fraud claims are meritless in any formulation. It's so bad. Mazajik saying keeping 5 and 9. No, keeping 4 and 5. Where we go? Breach of implied covenant, intentional interference with contractual relations, I believe. Is that right? Breach of implied tortious interference of contract and breach of implied contract. Breach of implied contract, and that would be this, intentional interference with contractual relations. This will be the tortious interference with contract. That's 5. I'm learning that tortious interference is also, intentional interference. So there you go. Okay, so there's a typo in the conclusion. That was a journey. Yeah, I think there's a couple of typos in here that show that even Liman gets it wrong sometimes. So nobody's perfect. Nobody's legal filings are without them. So this is where he talks about the motion to fees, right? And this is what I talked about at the beginning as well. They've moved for fees, and he said that, Lively has moved for a award of attorney's fees, treble damages, and punitive damages pursuant to California Civil Code. The court denies these motions without prejudice to renew in accordance with the ruling here. The court has ruled that the law applicable to the claims against Reynolds and Sloan cannot be determined absent further factual development. So this is what I was saying at the beginning. This is why I was saying what I was saying at the beginning about he's denied the fees, but he's not denying the fees because you don't have grounds for fees. You're not getting fees. I'm not going to award you fees. This is an anti-SLAPP. Like, you're not getting them. He's saying that, look, I've dismissed these so early in terms of like building down the argument. I don't even need to figure out choice of law for the claims against Reynolds and Sloan. So because of that, I can't determine yet whether I'm doing it under California law or New York law. You need to come back to me and help me develop that and come to a conclusion on what law applies. Then we'll talk fees. Right? If you want this under anti-SLAPP, if you want it based off the New York laws, you're going to have to make a case for why the claims against you are New York choice of law, right? I mean, they already had originally, but he's saying, like, I want this specifically developed out. The court has not ruled on whether Lively statements were privileged under California code. If the defendants choose to renew their motions, they shall fully brief the impact of this opinion, if any, as well as their issues raised in prior briefing. So he's basically just saying, go for it. The court has received several motions for leave to file amicus briefs. These briefs largely concern the application of California and New York's anti-SLAPP laws. The court has not considered any briefs in resolving the motions to dismiss, entirely because that question is still up. So, like, I know it might feel like, oh, he dismissed, but what about fees? He's basically teeing them up to say, give it another go, put together your best motion, and convince me. And I also think this is part of, I think Liman just doesn't want to come in here heavy-handed and make a decision when there are these big weighty issues, like with California Civil Code 47.1. So he wants to be convinced, right? He's not saying, I don't want to preemptively go in here and start making decisions because there are these big ramifications for it. I'm wanting you to actually put forward a good, solid argument. Like, give me reason to decide and file with you and align with where you're at. Rather than me just making like a snap judgment on it. So I do think those motions are going to come. I don't know when they come, but I think those motions are going to come. And I think, yeah, that's the amicus briefs that we've seen and the argument and the discussion that we've been having, and the one that we're probably going to continue this weekend about abusive behavior and stuff. I think that discussion is going to continue when Lively's team put it up there. And I will say, given Ezra Hudson's argument and that they seem to be an advocate with a lot of experience of advocacy in like this area, I think that's going to be really tough for Wayfarer to kind of argue against. I talked about the optics of it are really bad, right? Here's why we need to shred protections for sexual harassment survivors, regardless of Lively, right? You're doing it on behalf of everybody. Looks really, really bad. So I don't think it's a great optics look, but I also think it's going to be incredibly challenging for them to argue against. But I don't know, right? We'll see. I've been right quite a bit. We'll see. Oh, Mousy Jake says June 23rd, I believe. I think that's his date here. You can see the Wayfarer parties have leave to file a second amended complaint by June 23rd. And that will be just for tortious interference with contract and breach of implied covenant. So just those two claims. That's all they can file. They can file again for those two claims. Everything else is dead. They cannot bring them back. They cannot bring the New York Times back in. They can't bring Sloan back in. And they can't argue for, I think, Reynolds, predator statements. I don't remember what the intentional interference with contractual relations on the Reynolds side for the fifth clause is. So I might have to reread that before the weekend to figure that out. But anyway, yeah. So that's it. So that's it, closed and done. Big win, right? And I think anybody who says otherwise, like having your entire case, every single motion dismissed, it's huge. Very bad. And you can see from the arguments in here, the fact that Liman didn't have to dig very deep into technicalities of law as to what applies, what doesn't, here, where, and just basically wholesale said, no, look, you failed to actually meet the minimum requirements for pleading before we even get into a lot of like the technicalities of law. Really bad, really bad. But I think almost every lawyer called it and said this in the first place. So it's not a surprise, right? But here we go. Massey Jinx says, we did it. We did. It took 3 hours to get through. So I appreciate you being with me for it, because that is a long document. But thanks for being with me with it for me. So like I say, what comes next, they will probably file something else. I will not be surprised if there is like another stupid complaint that's going to talk about Van Zam and Taylor Swift and all the rest of it. It'll be interesting, because the problem he has is a lot of the other stuff is starting to allege criminal conduct, and particularly criminal conduct by other lawyers, which starts to get really serious. I don't believe Friedman can mess around and start accusing Gottlieb and Ezra Hudson of crime, and do so frivolously. Like, there are serious consequences to doing that. So it's going to be interesting to see if he actually backs up what he's been talking, because he's been talking and accusing everybody of crime for weeks now, right? Jones Works team of criminal fraud, of like breaching the Computer Act, extortion on Blake Lively's side. So yeah, we will see. Oh, and the Edgeworth thing. That's what I was thinking about. It's like there was a third one. I'm trying to think what the third one is. I'm trying to think what the third crime. I could have sworn there was 3 crimes he was accusing him of. The Taylor Swift extortion, the Edgeworth crime fraud exception, and I can't remember what the third one was. We'll have to come back to that. But anyway, he has to back it up and file something. But in doing so, he's going to be on very thin ice if he tries to like pull this stunt where he makes these like very serious allegations without evidence. So we'll see. Junk Pump says he should be disbarred for saying Jones forged emojis. I don't know. Like, I can see that he should be disbarred for saying that Gottlieb tried to extort Taylor Swift's lawyers. The idea that they wouldn't have already taken that up or gone after him for it, I don't know. Is iCloud Edgeworth? No, not quite, but it's related. Edgeworth are the people who she hired, Jones Works hired to investigate all of the websites and goings on in her like IT team that are doing it. They argue and allege Wayfarer that she only kind of worked with them to commit crime. The crime being the iCloud stuff, and therefore they got all of the permission to get all of her conversation and documents with Edgeworth, because they're no longer protected under litigation privilege. Not litigation privilege, sorry. They're no longer privileged under attorney-client privilege and work product privilege because they committed a crime, and that all got tossed. But yeah, I mean, he's been throwing out everybody committing crime, but Baldoni. So yeah, we'll see. I don't think that will come. I will say though, I will bring up though, the one thing about this, as I keep talking about, this was painful to go through in terms of like seeing how Judge Liman went through line by line. And I did make me come back to this whole argument months ago where Baldoni and Wayfarer were like, oh, we're not going to do and file motions to dismiss, right? This is not because we do not have grounds for motion to dismiss, but in this day of courts, giving wide discretion for leave to amend, we're not interested in providing Lively with a chance to learn how poorly their legal theory has been drafted and a roadmap on how to correct it. I thought this was ironic and interesting, because they should have filed a motion to dismiss. This is why, right? Having Liman go this detailed over your complaint, like, this is painful to read, like, and see him be so meticulous with the arguments. But in terms of like learning how poorly your legal theory has been drafted and a roadmap on how to correct it, Liman did that to Wayfarer and told them, there is no fixing this. This is so bad, it cannot be fixed. This is unsalvageable. So yeah, I just thought that was ironic, given their statement and their bragging about, oh, we're not going to do that, and tell them how badly they got it. Like, Liman did give you the roadmap on how to fix this, and there is none. It's to just burn it all and put it in the trash, and all of the money that you spent on this complaint and billed for this complaint was worthless. So yeah. All right, so like I say, we'll probably do this again. It will likely be Saturday when we'll try and go over the Davo stuff, because that's what I want to do. And yeah, I will no longer be saying we'll hopefully a quiet week on the docket. We've already seen a ton of other stuff this week, so I might even have to do a short third video this week to just kind of cover the weekly update, kind of maybe do like an hour short just to cover that, and then we'll do the Davo stuff. But I appreciate you hanging out with me midweek for this long session reading through the document. Master Jinx says, how do I do memberships? I will have to put that in the chat thing to do it. I need to redo and rework my memberships right now. As you notice, this is sort of the only content I'm producing. I'm not really producing any of the other content I've been doing. Life has just been very, very busy. I hope to get back to it. I will do a bigger push for memberships right then, just because it feels bad, right? I'm not making a ton of content. So yeah, we'll push for memberships in a few weeks when things quieten down and I can actually get to making more content other than this. But I will be dedicated to reading the receipts if nothing else, I promise you. So I love hanging out with you guys. Thanks for being here this evening. Have yourselves a great rest of your day, rest of your evening, and I will see you when we do this again. Like I say, likely Saturday. All right. Thanks again, chat. Take care. See you next.